everyone. Just before we start with the evidence, could I just raise two short points with it's Miss Ika Mail, I think, who's representing the Attorney General today. Two things, Miss Ika Mail. Firstly, the extended deadline for suggested questions from the attorney for witnesses on governance, that's the Auditor General, the Governor and the former Governor. They were due by yesterday. That's the time, the extended time that the attorney asked for. We've had no questions. We've had no application for an extension. So I assume that there are no questions. Is that right?
Good morning, Commissioner. We apologise for the delay and we will be submitting a response today.
Does that mean that you're applying for an extension? Yes,
please, Commissioner. Our apologies again for the delay in this.
I appreciate that the IU are very busy. We're all very busy. But directions aren't mere aspirations, they are directions. And so it's important that they are complied with because our timetable is such that any delay is severely disruptive now to our timetable. So I will see what comes in, if anything, later today in respect of those questions. The second is even more urgent. The extended deadline for written responses to the warning letters of Mr. Smith-Abbott and the Honourable Vincent Wheatley on Crown land was 4 p.m. yesterday. That again was an extended deadline. I indicated through the email of the 28th of September that it was unlikely to be extended for obvious reasons, because we're dealing with Crown land tomorrow. We have a hearing today. It would be impossible for us to consider any written response after 4 p.m. Yesterday. We have no written response, Ms. Ika Mail.
I understand that, Commissioner, and our apologies again for the delay with these written responses. The responses are currently with the Minister. We are working with him on that, and they will be with you today.
But how do you expect us to prepare for tomorrow? Crown land is a massive topic. We had massive disclosure, not in good order, very late, and now we won't have the warning letter with any time at all to prepare in respect of it. The response to the warning letter without any time at all to look at it and prepare for the hearing tomorrow.
Yes, and as I've stated, Commissioner, my apologies for the delay in this. We are working with the Minister on the responses and they will be with the Commission as soon as we possibly can get them to you.
But you understand the difficulty we're in?
Yes, I do understand, Commissioner.
Of course, we are dealing with a tight timetable and you're giving us no time to prepare on the basis of the response.
Yes, I understand that, Commissioner, and we will get them to you as soon as we possibly can.
Well, there we are, presumably again with an application to extend. But can I emphasise that the timetable is now such and the extensions that have been given are such that there is simply no leeway, Ms. Ika Mail. We need the documents as directed, or in this case, within the time that you, the IRU and the Attorney General said that they would be provided in. Okay, Mr. Rawat.
Good morning, Commissioner. Can I formally put on the record the representation this morning before I introduce our two witnesses? As will be clear, Ms. Martha Ekumeya appears on behalf of the Attorney General and the elected ministers. The remaining members of the House of Assembly are not represented this morning. Our two witnesses this morning are Mrs. Carolyn Stoutt-Igwe and Mrs. Sharleen Dabreo-Lettsome. The issue under consideration today is the arrangements under which the BVI government leases accommodation for its various ministries from private landlords. We will be asking questions of Mrs. Stoutt-Igwe and Mrs. Dabreo-Lettsome together. And the reason for that, Commissioner, is because their evidence will likely overlap in parts, and it's helpful if they are both able to assist at the same time. I understand that you both wish to make an affirmation. you should find on the desk the words of the affirmation. Can I ask that you take it in turn just to make the affirmations? No need to stand if you just read out the words on the card, please.
Thank you very much. Good morning, everyone. I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth.
Thank you very much. And thank you also for coming to give evidence to the Commission this morning. I know that you've brought some papers along with you, but you should have on the table some bundles which we will need to look at as we go through the evidence and the questions today. Could I ask you, or just remind you, please, as you're giving your answers, just to keep your voice up. The microphone doesn't amplify, it just records, and it is very important that we record your answers as clearly and accurately as we can. Can I begin by dealing with some formalities? Mrs. Stoutt-Igwe, could I start with you, please? Could you give the Commissioner your full name?
Full name, Carolyn Stoutt-Igwe.
And your professional address?
Professional address will be E.A. Creaky Building, Road Town, Tortola.
And can you give the Commissioner an outline of your career in public service, please?
Okay, my career in the public service spans a total of 28 years. Between the first part of my service was between 1983 to 1993, where I served in the Deputy Governor's Office with stints in the Ministry of Finance and the Office of the Supervisor of Elections. I returned to the public service in 2003 as the private secretary to then Chief Minister, Honorable Ralph T. O'Neill. I remained as private secretary to the incoming Chief Minister following general elections in June 2003 with Dr. Orlando Smith. And in 2007, after I returned to the territory for studying for my master's degree, I was appointed as an assistant secretary in the Chief Minister's office, now Premier's office. During that time, I had the privilege of serving as the Deputy Supervisor of Elections for the 2007 as well as the 2011 general elections. In 2009, I was promoted to the post of Deputy Secretary in the Ministry of Health and Social Development. In 2015, March, I was reassigned to serve as the Executive Private Secretary to then Governor Duncan. I was transferred to the Deputy Governor's Office in August 2016 to act in the post of Permanent Secretary in the Deputy Governor's Office. I was later confirmed to that post in December 2018, and I served there until September 2019, when I was transferred to the Ministry of Education and Culture as the Permanent Secretary.
Thank you. Mrs. Dabreo-Lettsome, can you give the Commissioner your full name, please?
Sharleen Dabreo-Lettsome.
And your professional address?
We are located in the second floor of the Burham Building in Road Town, Tortola.
And again, if you could give the Commissioner an outline of your career in public service.
Certainly. I entered the public service in June of 1994 in what was called the Office of Disaster Preparedness at the time. I served as the Disaster Preparedness Officer. And from 1999 to September 4th, 2019, I served as the director of that department. The name changed in 2003 to the Department of Disaster Management. That's in accordance with the Disaster Management Act. And then from September 2019 to present, I'm serving as the permanent secretary in the Office of the Deputy Governor.
Thank you. Now, as you'll be aware, the reason that we've asked you both to give evidence is to gain an insight into how all the processes and procedures by which government leases accommodation from private landlords. Now, as we go through, some of the questions may span different periods when you were permanent secretary of the Deputy Governor's Office. And what I'm going to do, if I may, is I'll direct my questions generally towards Mrs. Dabreo-Lettsome, but if at any point you feel that Mrs. Stoutt-Igwe is in a better place to answer, please defer it to her. And I think it may become obvious because we may be talking about events that happened whilst Mrs. Stoutt-Igwe was the permanent secretary. But if either of you wish to add additional detail to your colleague's answer, please do so. Now, as we understand it, that the arrangements in relation to the leasing of private accommodation is managed through what's known as the Office Accommodation Committee, which is chaired by the Permanent Secretary of the Deputy Governor's Office. Is that right?
That is correct.
And is it right that the Ministry of Finance is also represented on that committee?
That is also correct.
And who would, which officer from the Ministry of Finance would usually attend meetings of that committee?
It is usually the Deputy Financial Secretary.
And is there any other government ministries represented on the committee?
There are several.
Can you give us some examples, please?
Certainly. The departments that handle building inspections, which will be the fire service, the building inspection unit, the electrical inspection unit. We also have the health and safety officer within the Department of Human Resources. The Department of Disaster Management is represented. We also have, at times, the representatives from the survey department. And very recently, we've added others onto the list because of the current situation that we are in. There is a very strong relationship with the Attorney General's chambers as well as the Land Registry and the Inland Revenue Department. And also, thank you, the Environmental Health Department is represented on the committee as well.
And broadly, Mrs. Stoutt-Igwe, was that the sort of representation during your time as PS?
Yes, it was. I think a couple have been added, like DDM was added, but all the others were there when I was PS.
And in terms of an overarching policy, does the government of the BVI have an official policy in place governing how it enters into lease arrangements with private landlords?
I would say that in 2006, in January, from the records that I've seen, the responsibility for lease management was officially passed from the Department of Human Resources to the Deputy Governor's Office. In 2017, the permanent secretary at the time, who I believe was Otto O'Neill, and he prepared a cabinet paper that went before cabinet to approve a policy that is termed the Guidelines for Procurement of Office and Housing Accommodation, Tenancy Agreements, and Lease Management. Accompanying that document was also an accommodation framework that we have since improved and added to that. And very recently, we have began preparing what we call a public estate framework, which will allow the Deputy Governor's Office to have a better oversight on the entire estate that is owned by government. So the existing procurement policy and accommodation framework will become a subset of that overarching framework.
And you say, Mrs. Dabreo-Lettsome, sorry, that the sort of estate framework will relate to property that is owned by government, but will it also encompass property that is leased by government?
You are correct. Properties that are leased and properties that are owned.
Can you help me with this then? Because if we look at the main lever arch file, so I think, yes, if you turn up page 20, please. You'll see at the bottom of page 20, and this is part of an email exchange which concerned the leasing of the Cutlass building. But at the bottom, there's an email timed at 2:56 p.m. on the first. I think it might. Well, it depends on whether it's the American way of giving dates or the usual way of giving dates, but it is
7th of January.
7th of January, if it's the American style. And you're copied into that. And if we go over to the next page, 21, we see that it's from Cedric Malone, Permanent Secretary in the Premier's office, and he concludes his email with these words: might I suggest that DGO issue guidelines for public service engagement with landlords to help with navigating when financial commitments are made, to bring them more in line with cabinet decisions. This will minimize long gaps between when commitments are made and when premises can be occupied. We may look at some examples of the long gap, but the email was sent to Helen Duranta-Seymour, who is Deputy Secretary in the DGO. And we can see her response at page 197 in the bundle. It's addressed, forwarded to yourself, Mrs. Dabreo-Lettsome, and what the Deputy Secretary writes is, she refers to the email from Mr. Malone and says, generally there are no formal guidance notes with respect to the engagement of landlords on renting office space. What now obtains is that basic heads of terms outlining the cost of rent, square footage, amount per square foot, and any other fees which may be applicable are obtained from the landlord in order to present to the Office Accommodation Committee and then to Cabinet for consideration for renting space. Sometimes this information is forwarded to the Deputy Governor's Office by the requesting office. The requesting department also has to ensure that it has sufficient funds to engage in the rent before the request is formally submitted for consideration. Since there may be financial implications for renting office spaces, it will be necessary that clear guidance instructions are established to guide this process, i.e. a formal letter of intent be issued to the landlord on the proviso that approval to rent has to be approved by Cabinet before engaging in a formal lease, and that the intent does not constitute commitment. The Attorney General's chambers may be asked to vet or draft a standard letter for use. I therefore seek your guidance on how this process can be handled, what form of communication should be issued, and who should issue that communication so that it can be incorporated in the standard operating procedures for lease management and policy for acquiring rented properties, which can be communicated to the wider public service for guidance. If we flip back to page 19 now, so I think the Deputy Secretary's email that we looked at was a sort of internal one in the DGO, but returning to the ongoing correspondence, on the 10th of January, we see at the bottom of page 19 that Mr. Malone, in an email, said, I restate my concern and request for there to be a clear and structured process instituted to ensure departments, ministries, do not commit government to financial obligations to take space too far in advance of when such space can be occupied. Now, there may be the two different things going on at this, because you've spoken of an overarching policy.
Correct.
But what seems to be happening in early 2020 is a request from the Premier's office for guidelines. First question is, are there now guidelines, and what do they do?
I will present what I am familiar with in the 2 years that I've been there. The requests normally come directly from departments or from the ministries, and the request is received by the permanent secretary. There are times when you have departments and ministries who have engaged landlords with an interest in a property. It is normal that that information is communicated to us from the heads of department or the ministries. I have seen in the past that there have been some ministries that have engaged beyond what is defined in the guidelines. So there's a lot of discussion, and in some instances, a possible wording or discussion on commitment before the process is taken through the loop. I will defer to PS Igwe so that she can give a bit more explanation on what occurred in the past.
So in addition to what PS Dabreo-Lettsome would have said, yes, the procedures are there, but it is a responsibility once a department determines that they need accommodation outside of what they have currently, that they would be the one to explore available properties. And once that discussion is had, then they would send a formal request to the Deputy Governor's office. And to support what PS Dabreo-Lettsome said, the discussions and the initial phase is by the department or the relevant ministry. The Deputy Governor's office is not involved upfront. They are the ones who deal with that, and then they make the recommendations. And I think the heads of departments, ministries know that you cannot commit government for leases unless cabinet approves. So even if you decide that that is where you want to go, you would like to go, there are other factors, there are other checklists that the Office Accommodation Committee would look at, because when the applications are submitted, not every application that is submitted may necessarily be approved by the Office Accommodation, or I should say, may be recommended for approval, because the Office Accommodation Committee does not approve. The Office Accommodation Committee makes recommendations to the Premier. Once the Premier agrees with that recommendation, it is at that point that cabinet papers are prepared.
But take it back to guidelines. Mr. Malone is asking for guidelines. And I think the concern that he has is that you have departments effectively committing, or that there's a gap between the point at which a department commits to a lease and the period when you can occupy the building. Since the beginning of 2020, has the DGO issued any guidelines to ministries and departments on that topic?
We have still been using the procurement guidelines that are available. We've been using the outline of the framework that's existing to execute our work. What we have been doing is to have deeper discussions with department heads about ensuring that we receive as much information from them as possible, if they are the ones that are engaging the landlords before we are. There are many instances where the flow is started by our office. So we would get a memorandum from a head of department to say that they're interested in accommodation. They will provide details on square footage, the number of individuals in their office, and they would ask us to identify, because we do keep a listing of the available accommodations throughout the territory. But there are many instances, as PS Igwe said, where departments would go out to identify available spaces that they're interested in securing.
So no formal guidelines, but you have a process by which you engage with department and ministries.
Yes.
And in terms of policy, what you have is the cabinet paper from 2006, is that right? Which then, and the 2017 paper.
The cabinet paper from 2007, which approved the guidelines on procurement.
Right.
Correct.
And tell the Commissioner a bit more about what those guidelines of procurement provide.
The procurement guidelines takes us through the process for acquisition of office accommodations. So I would refer to the actual document that was sent to you.
Just to pause there, Mr. Dabreo-Lettsome, you sent through what's a sort of organogram. Yes. That is headed a lease management process map. Is that a summary of the procurement?
That is the summary of the procurement process, yes.
Right. And so you have procurement guidelines from 2007?
The procurement guidelines were initially developed in 2008 and they were updated on December 1st of 2020.
Okay, well, sorry for interrupting you, but if you just then explain the guidelines, if you want to refer to your diagram, please do so.
Thank you very much. On receiving the request for new accommodation, The request is usually written to the permanent secretary. The applications are stamped, they are recorded, and they're reviewed. And there's some very specific details that departments or ministries would have to provide. They would have to provide a clear justification for the need for the space, a history of the current conditions of their working arrangements, the staffing complement that they have currently as well as projected. They would have to identify whether there's budgetary provisions within their budget allocations or whether that will have to come from the Deputy Governor's Office allocation. And there's a projection of costs, which will include any outfitting costs that they would require. The next step would be for an actual site visit to be carried out by the Office Accommodations Committee at all of the locations that are recommended by the departments. And we have a site visit inspection checklist that is used to determine the suitability of those sites. Following that site visit with the OAC, there is a physical meeting that is called with the OAC members. A date and time is set for that. If it's a face-to-face discussion, there can also be round-robin discussions if there's an urgent need. We discuss the findings from the site visit and the general draft recommendations that have been prepared from that site visit. The report will also include the heads of terms that we would have acquired from the landlord, the verification of land and good standing details from the land registry, and we will determine from the department what move-in date that they'll require to initiate the lease. There are specific minutes that are prepared from that meeting, and we then agree on the final recommendations going forward. When I say we, I mean the members of the OAC. Those recommendations are then forwarded to the Minister of Finance for approval. He will make a decision. If he does not agree, we start the process over again to start looking for other accommodations that may be available. If he agrees, then that signals us to prepare a cabinet decision paper because there are financial implications. That paper is carried by the Ministry of Finance. We prepare the paper to authorize the use of the funding and to also authorize the conditions of the lease. There is a further decision made by Cabinet. If Cabinet says no, we start the process over again. If Cabinet says yes, the draft lease is then submitted to the Attorney General's chambers with all the accompanying documents that I previously mentioned. They vet that, and they also have an indication in that lease agreement, in the draft lease agreement, of the occupancy date. Once that is cleared the Attorney General's chambers, the landlord will sign, the Premier will sign, and both signatures are notarized. In order to make sure that we are keeping up with the process, we also notify the relevant department or ministry that approval has been received from Cabinet so that the payment process can be initiated, because the payment process can take some time. The lease is then submitted to the Inland Revenue Department because it is a government lease and you're engaging a private individual. We ask for a request for a stamp duty exemption. We then move on to the registration of the lease at the Land Registry and the High Court if that is required. Leases that are beyond 2 years are required to be registered. Leases that are 2 years and below are not required to register. I think I had 1 year, so we need to correct that on the chart. Most landlords agree that leases are registered. We do encourage it so that there is an official record that is with the Land Registry and the High Court. The information is then entered into a database that we manage, and the database is used to generate several reports. Reports are generated on a monthly basis, a quarterly basis, and an annual basis. The original lease is then provided to the landlord. An original remains with the Office of the Deputy Governor, and an original goes to the Land Registry. We then make copies of that lease, and copies of that lease is shared with the head of department, the Audit Department, the Treasury Department, the Ministry of Finance, and the Inland Revenue Department. The building is then occupied, and we begin our inspection process. Our inspection process is defined in another document which determines how often we enter the premises to ensure that conditions are remaining as contained in the lease. If there are issues with inspections or during the inspections or issues with maintenance, the first point of contact is usually between the department and the landlord. If it escalates beyond the point where there is no response coming from the landlord or the tenant is not happy with the current conditions, then we get involved at that stage. So that ends the process you will see in yellow for new leases. If there is a lease renewal process, the department will then be notified by us because our database will trigger that renewal date is coming up. We will formally write to them for the need to renew the lease, for them to provide feedback on whether to renew or not to renew, and whether there is a need for any changes in the terms and conditions of those leases. The Deputy Governor's Office then writes to the landlord to indicate an interest in renewal or termination of the lease and any changes to the terms and conditions. A decision is made by the landlord whether to proceed or not. If the landlord says no, we go back to the beginning of the process. If the landlord says yes, there is an inspection by the OAC committee to verify the suitability of the site for renewal. And again, we use the site inspection checklist to verify the conditions are met. There's then another meeting of the OAC committee, and very recently we've been having a lot of virtual meetings because of the COVID environment. We discuss the findings of the site visit and we agree on the draft recommendations that will be put forward. Minutes of that meeting is held to confirm the recommendations, and then the recommendations are forwarded to the Minister of Finance for his approval. Again, he makes a decision. If he says no, we start over again. If he says yes, it does not go to cabinet at this stage. It goes to the Attorney General's chambers, and then it follows the process again until the lease is finalized.
Thank you very much for that. Shortened probably quite a few of my questions, which is always a good thing. The process map as a document, how long has that been in existence?
This was recently developed because in preparing for this, there was quite a lot. You will see that I have a very large folder with me. And in going through the documents themselves, I wanted to have a visual presentation of what it represents. So what you see in the flow chart is exactly what is contained in the document.
I see. So would a fair way of putting it is that the flow chart that you've produced is one produced because you received a request from the Commission.
Correct.
But it is intended to reflect the overall process, which is encapsulated in the 2008 policy that was updated as of the 1st of December 2020.
That is correct. We have not made any changes from what's here. As I did say that there was a correction because in the document it says leases 1 year and below do not need to be registered. But in checking through the legal documents, we've been notified actually by a law firm that it's actually 2 years. But I left it here because it's a reflection of what is in the document.
And Mrs. Stoutt-Igwe, can you confirm that that as a process was the process that applied when you were permanent secretary?
Yes, it was.
Can I just ask some questions following on from what you've just explained, please, Mrs. Dabreo-Lettsome? Firstly, is that you spoke about the need to register certain leases. Does that mean that they then they are public documents if they're registered, and the public can come in and see effectively leases that government holds with certain individuals?
They are registered with the court. I am going to have to ask my colleague
once it's registered, it's a public document.
And a lease will contain obviously the names of the contracting parties. Do you redact addresses or any details from them when you lodge them with the court?
No, we submit the lease as it was signed.
With all the details? With
all the details. Whether or not the registrar's office has any restrictions, I don't know.
Thank you. So you spoke of inspection checklists, and as I understand it, your office will be involved in inspections before the lease is signed off and then during the currency of the lease. Is that
Correct.
right?
That is correct.
And in terms of an inspection checklist or an inspection policy, is that a separate document that you have, or is that enshrined within the policy that you've drawn our attention to?
It's enshrined within the policy.
And you said that landlords are encouraged to register. Does that mean that landlords, I mean, obviously 2 years and above it has to be, but what are you referring in terms of encouraging landlords to where you have leases of less than 2 years? You would encourage them to do that?
Yes.
And what's the benefit to the landlord of taking that step?
I believe from what I'm aware, and I will ask my colleague just to support this, from what I understand is that the process, we wanted to ensure that there is a documentation of the final lease with the courts. We wanted to ensure that that document is lodged with the court. Some landlords are very willing to do so. Others have said it is not a requirement. As I said before, we did not request those that are below 1 year to be registered. We did ask for those above that 1 year period, and I've seen evidence of that to be registered, and they have been.
Now, broadly, and very broadly, the sort of the types of accommodation that your office will be involved in sourcing and putting in place can be split into two. You have what might be described as office accommodation, from which various ministries and departments will perform their functions. And so those will have particular requirements from all sorts of perspective. But the second element of that is that you're also involved, are you not, in, for certain, for example, judges or teachers or police officers, you're involved in sourcing housing accommodation.
Correct.
Does that kind of accommodation again come within the ambit of the policy that you've just outlined?
Yes, there are specific requirements that come from the Eastern Caribbean Supreme Court for judges. And we have provided an inspection checklist for what we would use for accommodations that are outside of the judges' arrangements.
Could I ask for, and I think this is probably more for Mrs. Stoutt-Igwe, but if the bundle, if you turn up in the lever arch file, thank you. Just turn up page 26, please. Page 25 first, and this is the minutes of a meeting of the Office Accommodation Committee on Wednesday, the 24th of October 2018, and we can see for that meeting with officers from various departments, including the Ministry of Finance, and as you pointed out earlier, the Environmental Health Division. One of the points that you said, Mrs. Stoutt-Igwe, is that you explained that landlords were demanding rent increases, some outlandish, since the passage of the 2017 hurricanes, although they had not made any improvement at all to their accommodation. And you said that some landlords were more approachable than others when it came to the care and maintenance of their buildings. There was then discussion of developing trends in the rental market. And Mr. Glenroy Forbes, who was then the financial secretary, advised that the Office Accommodation Committee needed to come up with a policy to determine what level of property the government should be renting, and that health and safety procedure in the workplace should inform that policy. And then if we go to Lease, he recommended some basic requirements to be met, which if they were not included, government should not be renting the property. Mr. Forbes then went on to emphasise that the range and what should be allowed has to be informed by what the landlord is bringing to the table, as opposed to giving only a shell. He explained that if the accommodation is a shell, then the price should be different to if it's more than a shell. The more the landlord brings to the table, the higher up the scale the government might be willing to go. Mr. Forbes then continued that government must be fair to the landlord, whether looking at the movement of insurance premium for property or the going rate for office accommodation in the economy. If we then go to page 27, we have Mr. Claude Kettle, who was also from the Ministry of Finance, advising that basic criteria must be met and adhered to, and stating that if added features such as functional elevators are included, the base rate can be increased slightly. But if there are no additional features, the base rate should not be increased no matter how nice the building is. So Mrs. Dabreo-Lettsome, I think, has outlined a process within the Deputy Governor's office of how a lease arrangement runs from start to finish, or how it should run. Now, first question to you, Mrs. Stoutt-Igwe, in terms of the policy that Mr. Forbes was advocating for, what was that directed to?
Following the hurricanes, a number of properties were devastated, including some of the rented properties. Insurance premiums started to increase. So of course, there were some landlords, especially like if the leases were up for renewal, they started submitting notices that the rents would increase. So in the case of, there were some properties where we could see that landlords had to invest significant amount of money to get their buildings back up to speed. Others, very little change was being made to the building, but they were still asking for increases. So that is one of the reasons why you would notice that Mr. Forbes was there as a guest, because the financial secretary would not usually attend meetings, but we invited him because we realized that there was a trend and we needed some guidance from him as a financial secretary. So we had various notices of increases, and that's why we called a meeting to start to discuss the way forward, because, and when he talks about the shell, in that over the years, the types of properties that government was renting for offices had changed. In earlier years, buildings were prepared, restroom facilities. If you needed to have 10 cubicles, 10 divisions, those were done. But in recent years, basically, all you got was a shell.
And government was responsible for then fitting out it all?
Yes, for doing all the outfitting of the buildings.
And you say recent years, using the hurricanes as the benchmark. How soon before the hurricanes was government having to then engage in the process of fitting out its own offices?
That trend have started happening before the hurricanes, actually. In the 80s, I remember 90s, probably it was the older way of doing things. And I think probably in the 2000s, somewhere in the 2000s, trends started to change.
But what I mean, it's obviously very difficult to have fixed criteria, because it'll depend on the type of building that someone is looking for or that's being offered to you. But what Mr. Forbes seems to be pointing to is the idea of some baselines.
Right. So that's why we were agreeing that there were some, if we're looking for a building, there were some basic guidelines that we wanted to make sure we have. The building must satisfy this basic criteria. And then there were some fringe benefits with certain buildings. For example, if you're going to be having a building on a second floor, there must be alternative exits, for example. All right. You can't just have buildings where if something happens, there's only one way in and one way out. So there was some basic criteria that we started to look at in terms of what we should be looking forward to approving as we move forward as leases, because some leases would have been going on for years, but those, as we are engaging in new leases, he was saying, let us start looking at our standards and our criteria that we're going to require before we engage in some of these new lease arrangements.
And how far were you able to take that?
I think from that discussion, then we started to come up with some new checklists. I think PSW talked about some checklists. So since this time, we came up with checklists, and what we had each agency do was based on their expertise. they started to give us guidance. For example, with the fire department, we know that when they go out, there were certain things they looked for. So what we started to do was to formalize the process in that we had different checklists for different agencies. So environmental health would have a checklist, finance had a checklist, occupational health and safety checklist. So from this discussion, this is where this new commission, where you see this office accommodation checklist, that's where that derived from, this new meeting going forward.
Now, Mrs. Dabreo-Lettsome, you said that the policy was updated the 1st of December 2020. So do we take it that the work that started with Mrs. Stoutt-Igwe's committee meeting has over time evolved so that you were in December 2020 able to add that into the policy?
Yes, that is correct. There are 11 checklists in total, and there were also some other conditions that I saw. Igwe did quite a bit in trying to come up with some general standards. So there was, the building would be occupied with some basic areas. Then the add-on items that will come as part of a maintenance agreement would be for generators, or in the case of homes would be for gardening to keep the landscape in order. For the housing accommodations, the maintenance of pools is not covered by the government. In addition to that, there were also some very specific range of costs for elevators, maintenance of elevators and common spaces. We also set a rate for the lease amounts per square foot that we will consider, and this was based on the increases that were occurring. So we do have a cap on what we are allowed to engage landlords on. There was also an agreement on the outfitting, the extent of the outfitting that the government will be involved in. And there was also the need, following the hurricanes, I also saw that there was a requirement for the certificate of occupancy to be presented to the committee from the building authority.
You explained you have a cap. So for square footage, is there a level that you will not pay above, basically?
Yes, that is correct.
And is it a range that you give in terms of guidance to departments, or is it just has it been promulgated to departments on the basis of, well, you don't pay above this threshold?
It is a range, and it's about $10 below the market value.
In terms of, and presumably, is it different for whether you're looking at housing accommodation as opposed to office accommodation?
That is correct.
Both or either one of you may be able to answer this, but obviously there was an impact on the market following the hurricanes, and Mr. Stoutt-Igwe has explained the position that some landlords took. How has the market changed subsequently? And
what I can say is, following Irma and Maria's impact, at the time we had 11,770 buildings registered in the territory. The losses was over $900 million, and there were 58% of the buildings that were classified as having major damage. That meant that many of them could not be repaired. And we saw the majority of government buildings that were owned, and a large percentage of those that were leased fell into that range of excessive damage. I don't know if I can identify from my time at the Department of Disaster Management any building that did not have impact, whether it was impact to glass or impact to doors or the landscaping. The market, as PS Igwe said, has changed. There's been an increase, but there's also been a change in the use of buildings through the planning authority. So you do see quite a number of buildings that were outfitted to be more of warehouse formations that have now been converted to providing office space at a lower cost. And sorry.
No, please finish. I'm sorry.
No, I was just going to say, and you will see from the records that we've presented that there's a combination of the types of buildings that we have selected to be used for government accommodations, office accommodations.
In terms of, you've said that there were sort of over 11,000 buildings, and is that over 11, before the hurricanes, you had over 11,000 buildings that government was using, either because it owned the building or because it was leasing the building?
No, this is over the entire territory. I just wanted to present a picture of the level of the impact.
The impact.
Yes.
But I think you've explained that if the greater majority of government buildings were just like private homes, also impacted by and suffered damage as a result of the hurricanes.
Right.
But taking it to today, in terms of what proportion of if you like, the government estate is owned by government as opposed to lease?
I know that I looked at a list this morning that we constructed sometime after the hurricane. The government owns over 100 buildings. And leases, so we don't lease 100 buildings. You have a list of leases?
We are currently, as of the database from 2008 to present, has a total of 119 leases included. That's including those that have been terminated. As of the end of, sorry, I had that this morning. The end of last year, we had 75 buildings. These are homes, office spaces, land for parking, so forth, combination. We had 75 of those buildings in the database that had active leases. In terms of the percentage, I will have to rely on.
But what we have is government owning 100 buildings and currently leasing 75, but that covers all the uses that government might put buildings or land to, which includes, as you said, accommodation or even parking.
And storage. There's small spaces for storage as well.
If I could just ask you, Mrs. Dabreo-Lettsome, just to take back the lever arch file and just turn up. You may have it separately, but it's your memorandum that you prepared of the 23rd of March, 2021.
May I please have the page number?
One, please, just the first page. Now, I think you can see that this is your memorandum, and it's a memorandum to Financial Secretary. And it is dated, as I've said, 23rd of March 2021, and the subject is Commission of Inquiry Request. And I think when some of the helpful background that you've put in is drawn from cabinet papers that were drafted at an earlier point in time. And you've explained in terms of background, the steps that had to be taken following the hurricanes to find new accommodation for public officers so that they could carry on their functions. And in particular, if we see on page 1, you deal with the need to relocate public officers from the Central Administration Building, as it then was called, whilst it was being renovated. And you then continue through the next pages to set out the efforts that were made to find alternative accommodation, and ultimately you deal in this memorandum with the government entering into a number of lease agreements for different departments. Could I ask you just to turn to page 12, please? And again, this is hopefully drilling down a little more into the process that you outline. But at F, you set out the different agencies that the Office of the Deputy Governor will liaise with in relation to the lease management process. And the first one, the Roman numeral 1, is department heads. And you write there that department heads will request new accommodations and lease renewals. In terms of requests, I know that ultimately it's the office makes a recommendation. Can you, the Office Accommodation Review, can you refuse a request from a government department?
I'm going to ask my colleague because I think I only have one example.
Yeah.
She may be able to.
I don't know that we can refuse, but there are cases where a request may not be advanced. Because if you can clearly see, I know that I dealt with some after the hurricanes where the prices were exorbitant and we just were not going to advance it. It didn't make any sense to advance it. We asked some persons to go back to the drawing board, look for something else that is a little bit more reasonable. So I don't know that we can refuse, but if they've submitted something and we know that they don't satisfy some of the basic criteria, we are not going to advance it. Of course, we would not advance it with communicating to them that it doesn't make sense to go forward. Again, if you're submitting a request and you don't have funds in your budget to cover the costs, there's no reason for us to advance it. So those are the cases where it will not be advanced, but I wouldn't say it's refused.
Yes, so what you can, you don't refuse to consider it,
Right.
But what you may conclude is that you won't make a recommendation.
No.
And that decision may be based on saying to the requesting department, either you won't have the budget to cover this, or it doesn't make economic sense to do it.
To even advance it to the Office Accommodation Committee, because if it doesn't satisfy the basic requirements for the Office Accommodation Committee, there's no reason to advance it there.
I see.
So rather than wasting their time, just tell them out front, you're not the Office Accommodation Committee to make the final decision. But if there's some glaring things up front, it doesn't make any sense. Go back to the drawing board. And there are some people, some offices that went back to the drawing board and found alternative arrangements, accommodation that were more suited, that were also within budget and also satisfy the needs that they were looking for.
So in fact, the Deputy Governor's Office, you're one step between the requesting department and the Office Accommodation Committee. You can actually act as a filter and say, no, you have to think again about what is that you actually want.
Yes.
Or we may not engage another lease. We may engage the landlord on a month-to-month payment basis. So there are some times where you have landlords that have not been able to address concerns in the building, maintenance concerns, and we have not extended the lease. We have agreed to go on a month-to-month assignment with the landlord until those matters are addressed.
See, you also write, Mrs. Dabreo-Lettsome, is that the office also addresses any accommodation issues which may arise. Now, this may take us back to the inspection checklist that you were speaking of, but in what way does the Deputy Governor's Office address accommodation issues?
We have a team. It is a small team, and that's why we rely on many of the other departments to go along with us for that checklist. That's why we've also increased some of the departments that sit on that committee because they are able to really determine whether sometimes you go into buildings and you may see cracks that may trigger some signal of possibly a foundation issue. Sometimes there's mold that's present and we need to have environmental health undertake special assignments to do that. Many of the complaints come directly from departments, but we have had instances where departments have engaged other departments, such as the Department of Disaster Management, to undertake what you call a non-structural assessment. And coming out of that report, that department would have identified some particular issues that would need to be addressed. And then we are notified. There have been instances where there've not been a good relationship between the department and the landlord, and we have gone in and brought in the team to undertake an inspection ourselves to determine what exactly the issues are.
Are there occasions when the department, if you take a crack or mold or whatever, when the department will engage with the landlord itself or engage with another department of government other than yourselves to try and resolve the problem?
We encourage that because, as I said, our team is very small. So we do encourage them to use the conditions of the lease because a copy is made available to them so that they can engage the landlord to try to address the matters at that point in time.
So are you almost a backup service, if which, and you're an option they can use, but not something that it's not mandated that they must come to you whenever anything goes wrong in the lease?
No, it's not.
If you look then at 2, it refers to the office accommodation committee, and you say that it's one of the things the committee can do when in its work is, and this is on page 13, is to make recommendations for improvement in the lease process from time to time. Could you just develop that a little, please, for the Commissioner?
I will ask my colleague to add to this, but we have had instances where, for instance, with common areas, there's been a request by some landlords for that area to be paid for by the government, and we have had to have specific negotiations with them and make recommendations to Cabinet on whether that should be entertained or not. I am drawing a blank to the other examples right now. Maybe.
Can you repeat the question?
It was examples of the circumstances in which the Office Accommodation Committee will make recommendations for improvement in the lease process.
Okay, so I think that goes back to the checklist that we would have implemented in terms of making sure, for example, you might have had a lease for a number of years, but now you're getting ready to renew it. And there are certain things that the checklist will then ask, that you ask to look for now, that to help improve as you move along. Because there were years ago, we didn't make a big fuss about stairs, climbing stairs and stuff like that. But now you have to think more about persons with special needs and access. Access is no more of an issue than it was years ago. So things like that you will now look at, but more like, I would say, the checklist that we have put in place would be where some of the improvements will come.
So the point goes to specific lease arrangements rather than the overarching lease process that you were speaking about, Mrs. Dabreo-Lettsome.
The overarching lease process has not changed since 2018. It's remained consistent. What we've done is just look at the lease process within a bigger picture. So the lease process is now a part of public estate management.
Which is a policy you're developing.
Correct, because 2 years ago, we received approval to hire what we call a public estate manager, someone with specific skills in this area. Before that time, this entire process was being handled by the permanent secretary and the deputy secretary. Now you can understand how difficult that is because there are other policy level decisions, and this is very technical and requires someone with very strong environmental planning and building skills. So we have been able to bring 2 individuals on board to work with the other 2 members of that team to strengthen the process further. And one of the recommendations coming out of that has been to look at it in a more holistic fashion to come up with an entire strategy for the management of the estate.
And is there a long-term goal in terms of the, I'll call it the public estate, in that is it the expectation that government will own most of the building it uses, or is it the other way, that government will actually rent most of the buildings it wants to use?
The intention is to decrease the amount of money that we're spending on leases, but to strengthen the maintenance of government-owned buildings and to ensure that those buildings are adhering to the same standards as private buildings. So creating more enforcement in the retrofitting and the design of new buildings. So when this government came into power, they adopted the SMART standards for building designs, which is internationally recognized now, that you design buildings that are safe, that are healthy, that are green, that are contributing to energy reduction. So in working with the Recovery Development Agency on the government buildings that are being retrofitted, we have ensured that those conditions are built in, and at the end of that process with the RDA, that a maintenance manual is handed over to the government so that there is guidance on how those buildings should be maintained going forward.
Could you tell us a little bit more about how the Deputy Governor's Office works with the RDA?
The RDA provides for repairs to government buildings, and there are some specific buildings that are handled by our office. They engage ministries directly, depending on what is being done. If there are buildings that are not directly with us, for instance, there's schools that are being repaired, there's an information sharing process that we will be able to receive information on what is being done to schools, what is being done to recreational parks. So I'll give you an example. Yesterday, I got an email from Education that they were handing over a recreation park in Anegada on Sunday. So we've been invited, we've received information on what was done, and we have an indication of the scope of work. So that helps us to be able to provide that documentation on the estate that is necessary going forward.
Your public estate management framework that you're developing, is it focused on what I've been calling government buildings, which is where public officers either live or work, or is it wider than that? Is it intended to bring in to the fold schools or recreational parks?
Yes, everything that is owned by the government. We've actually just recently received some funding from the FCDO to engage with the RCIS, which is an institute in the UK, which will help our officers to be able to understand how to apply a value to the estate. Whether
is that the Royal Chartered Institute of Surveyors?
Thank you. Yes, that is it. Yes. Yes.
And so that you going forward within, when you say our officers, is that officers within the Deputy Governor's office?
This is the Deputy Governor's office.
And so it's part of the policy development for the future that you will actually be able to put a proper value on the estate.
That's correct. We are not only training members of our office public estate team, we are training, I believe there's 7 members of the OAC team located in different government departments that are qualified to be able to receive that training and become certified in the evaluation process. But there are buildings, for instance, the emergency shelters are managed by the Ministry of Health, schools are managed by the Education Department. So it's really to just create that overarching framework that determines what the estate looks like and what is the value of the estate, so that not just the Deputy Governor's office, but any ministry wanting to make decisions for the future use of those buildings, that they have access to that information in a database that we are also developing through that funding.
And in terms of timelines for, we've spoken about an overarching framework, training officers in valuation and building up a database. Have you got a timeline for that work?
I do. The database and the training will be completed by March of next year, and the framework will be hopefully presented to Cabinet by December of this year.
And is that the sort of Cabinet is the ultimate arbiter? Is it? The work you will do will find its way into a Cabinet paper that will then be either agreed to or possibly amended or sent back by Cabinet.
The public estate framework, yes.
And who gets to put that in front of Cabinet? Does it come from the Deputy Governor's office itself, or does it go through the Ministry of Finance?
Because it's a policy document on the estate, and the estate is handled by the Deputy Governor's office, we will put that forward. If there are financial implications within the paper, then the paper will be transferred to the Ministry of Finance.
Returning to your memorandum, please, Mrs. Dabreo-Lettsome. On page 13, you refer to the Minister for Finance and the Ministry of Finance as 2 separate entities. Just clarify a little bit the difference in terms of the roles that the minister will play as opposed to the ministry.
From what I understand, and again, I'll ask my colleague to correct me if this is wrong, the process that's defined in the document calls for an engagement with the Minister of Finance through the Ministry of Finance. So if there is a Cabinet paper that the Minister of Finance is taking to Cabinet, that paper will be sent to the Financial Secretary for his comments and for him to ensure comments are received by the Attorney General's chambers, and then that paper is carried to Cabinet by the Minister of Finance.
Right, and in addition to that, the reason for the engagement of the Minister of Finance before the paper is prepared, because you're asking, the paper is being prepared by the Deputy Governor's Office. So before the paper gets to Cabinet, the Minister of Finance, because you're spending the government's funds, must have given approval for the government to go and engage with this new lease arrangement. So that's the reason why we get his approval prior to going to Cabinet, so that he's aware of the decision that was taken. The recommendation came from the Office Accommodation Committee, but the Minister of Finance needs to sign off, and then we prepare a Cabinet paper, because you won't want a situation where you send a paper to Cabinet, Minister of Finance, yes, he's taking the paper, but he has no knowledge that we are getting ready to spend money on this, because it could be a case where, yes, we are making a recommendation, but maybe the Minister of Finance might have had another idea as to how this can be done. So you want to make sure that the Minister of Finance is aware of what is taking place ahead of the Cabinet paper.
So, if you break that down for me, please, Mrs. Stoutt-Igwe, perhaps hopefully not oversimplifying the process,
Okay.
but a department might come to the Deputy Governor's Office saying, we would like to rent some additional space. This is where it will be. If it meets the basic criteria and doesn't sort of cause the permanent secretary in the Deputy Governor's Office to raise an eyebrow or two, it'll go to the Office Accommodation Committee. That committee will make a recommendation, which will then go to the Minister.
Correct.
And because if the Minister approves, you draft up the paper, but it is actually taken to Cabinet by
the Minister of Finance.
And therefore, on its face, it will look as if it's emanating from the Ministry of Finance as a paper.
Right, it will become their paper because it is coming from the Minister of Finance. So we're basically just transferring the paper to them.
So the draft leaves
subject.
you, they finalize it and put it in front of Cabinet.
Correct.
But from a budgetary perspective, at the end of the day, does the requesting department that initiated the entire process right from the beginning has to have that money in its budget?
Yes, that's a part of our requirement in submitting and preparing the paper to go to the Office Accommodation Committee. There's a financial section that we have to indicate that the office has sufficient funds within their budget to advance this paper.
See. On the table, you'll see a smaller lever arch file, which contains an affidavit which has been provided by Jeremiah Frett, the current Financial Secretary. And Mr. Frett will come a little later to speak to that affidavit. But if I just draw your attention to the first page of it, because he's got a heading, Process of Approving Government Lease Arrangement with Private Landlords. And he sets out that the management of leases for privately owned properties is currently the responsibility of the Deputy Governor's Office. He explains that as you've said, that the ministry is a member of the Office Accommodation Committee, and the Deputy Financial Secretary sits on that committee. What he says at 2.3 is the committee considers and makes recommendations for entering into lease agreements on behalf of a government department. If we look at 2.4, Mr. Frett continues, the committee's recommendations are submitted to the Minister of Finance for approval. However, as the recommendations are submitted to the Minister of Finance through the Premier's office, the ministry is unable to provide any copies of these recommendations. This is Mr. Frett's explanation for why he couldn't provide certain documents. I should also add that I'm unaware of why the recommendations are submitted to the Minister of Finance through the Premier's office, and that the Deputy Governor's Office is likely to be the department with the knowledge of why it is done this way. So Mr. Frett has set you both up nicely to possibly, I hope, explain that detail of how it works. Because obviously, as we know, the Premier is always also the Minister of Finance in the BVI. I mean, you don't have to agree with Mr. Frett, but is that the way it works? And if it is, why is that the way it works?
I guess because the Minister of Finance Well, there was one instance when the Minister of Finance was not the Premier, but so I'm not sure how it was handled. But I think because the Minister of Finance sits in the Premier's office, that is where the correspondence goes. Do you have anything where a sample of any of the memo that went to him?
I will have to search, yes. But PS Igwe is correct. The correspondence is addressed to him in the Premier's office. Those are the recommendations that come from the OAC. I think it's just really just to advance the process because he's not physically sitting at the Ministry of Finance. But the Ministry of Finance will receive the cabinet paper, which will have the exact details that would have been communicated to the Premier in that recommendation from the OAC. And in addition, his representative is on the OAC committee, so he would have had a sight of the document that is being communicated to the Premier.
And been involved in formulating that document.
Correct.
So is the reason it goes to the Premier's office purely because the Financial Secretary is physically in the Premier's office?
The Financial Secretary is not physically in the Premier's office.
Right. So why does it go to the Premier's office?
The Premier is the Minister of Finance and the Premier sitting in the Premier's office.
No, I understand that the Premier and the Ministry of Finance are one person, and usually, not always, but usually are the same person.
Yes.
But I'm just wondering why it goes to the Premier's office rather than to the Ministry of Finance.
I think if you look through the correspondence that we've provided, you will see that we write to his private secretary to say that this is for the Premier, but she's copied in so that she's aware that we need to get the lease advanced. So it's really just a way to get the process going quickly.
Yes. So we know the Ministry or the Minister actually of Finance does have input because he's effectively got to sign off the money.
Correct.
But the Premier's office doesn't have any input in that sense. Is it really just a conduit, so far as you're aware, to get to the Ministry of Finance?
That is what is said in the procedures, yes.
I understand that.
Is it just a sort of historical consequence of the fact that the Premier has very often been the Minister of Finance? So if you want to get something in front of the Minister of Finance, you get it in front of the Premier, and that speeds things up.
Correct.
But although it's addressed to the Premier's office, when it lands on his desk, what you want him to do, or she to do, is to put on the Minister of Finance hat and consider it.
Yes.
But in terms of the knowledge that the ministry will have, firstly, it's because they input into recommendations.
Correct.
Secondly, if the Minister of Finance sends back a recommendation and says, I don't think this will work, the Office Accommodation Committee has to reconsider it anyway.
Correct.
And again, the ministry will be involved in reformulating that.
Yes.
And the accepted recommendations find their way into a cabinet paper that the Ministry of Finance signs off.
Yes.
In effect.
The members of the OAC also sign off on the recommendation. So there are lines for each person that's represented on that committee to sign.
Now, one of the features that we see is that the Premier signs the leases on behalf of the government of the BVI. And is that the case with every lease that the Premier will sign every time?
Yes, as far as we are aware, similar thing that is done for contracts. The Premier is the one who signs.
And has that ever changed with different administrations? Does the Premier ever delegate to other ministers or officers the signing of leases?
I'm not sure about leases. I know in the past there was delegation for contracts to different ministers, but I'm not sure about leases. So those that I've been involved in, I know it has been the Premier.
So your experiences across your time as permanent secretaries has been it's the Premier that signs off.
Mr. Rowd, I know the time.
Could I ask two quick questions?
Find a convenient break and then we'll break. Thank you.
Just two quick things, just again about the process. The papers refer to the Facilities Management Unit. What does that do?
This is the government's facilities management mechanism to support. It's really originally designed to assist with maintenance of the central administration building. But through the public transformation program, what I've seen since my time in the office of the Deputy Governor as permanent secretary, there is now an idea to have a centralized facility management department that will deal with the maintenance of buildings across government. That has not rolled out fully. That responsibility used to be with the Public Works Department, but we do engage the facilities management unit because they do have expertise to assist with the repairs to government buildings.
And is that government-owned buildings or also government-leased buildings?
Government-owned buildings.
And the Public Estates Committee?
We do not deal with maintenance of the buildings. There are times when we are able to work with the Ministry of Finance to hire a contractor. If the maintenance issues are beyond the facilities management unit, then we will get involved with overseeing that contract and making sure that the conditions and the responsibilities from our end are met.
And that's the work of the Public Estates Committee?
Yes, it is.
One last matter before we break. There's references in the papers to a comparative assessment report. Is that, does that sort of, is that something that you can shed any light on?
Is that
Where is that reference?
Give us the reference, please.
That is the one thing I can't do.
Oh.
So I have not been able to find it again. So,
Okay.
but that allows this another good reason for having a break now, and I'll try and find the reference.
We have a stenographer, and he just needs a break after an hour or so. And so, if we take 5 minutes now, we'll come back and complete your evidence.
Okay.
Thank you very much.
Where is the House of Justice?
Good, thank you, Sir Howard. We're ready to continue.
Thank you, Commissioner. Commissioner, I haven't been able to find the reference to comparative assessment report, so I think I'll move on if I may. Could I take you back, please, Mrs. Dabreo-Lettsome, to your memorandum, and that's at B2 in that large file we're looking. If you look at the top of the page, so it's number 2, page 2 in that bundle. It's the top of your memorandum. You've said the Public Estates Committee held on the 16th of December 2019 a meeting at which various departments were present, including your office. And various accommodation was considered, and that was in the context of trying to find accommodation for approximately 300 public officers that had to leave the central administration building. And if you look further down, there's a paragraph that begins, in viewing the potential spaces, it was noted with concern the heavy congestion in the road town locale. Consideration was given to widening research, and other accommodation was then identified in various locations. Now, what then goes on, if you go to page 3, and this may just be drafting, and it comes from a cabinet paper, but you write, in addition to the previously recommended properties, Cabinet was also asked to consider 2 additional accommodations that could serve to house government departments if necessary. And then you say, based on size, location, readiness of the space and cost, following properties were identified as additional accommodation. And then if you go over, I'm thinking in a moment. What's listed is sorry, give me one moment. Yes, if I take you back actually to page 2. This question, if you could just clarify it. You have at the top various accommodation, for example, in Seacow's Bay, Fish Bay, the RG Hodge Plaza, Cutlass Tower being considered. And then you make the point that there was concern over heavy congestion, availability of parking, etc. And then you list the same locations. And it's just to clarify, it seems to be that because of the heavy congestion issues, you were suggesting alternative locations, but they're the same as those that were previously recommended.
Some of them are. The point that we were making there was that it was not a norm to go outside of the central road town area to identify office space for government. Because we had the challenge, we started to search outside of the outskirts of road town. So the Fish Bay area is more of an industrial developed area that was transitioning to be more of a commercial area. And so we reached out. I'm not sure if you're aware, but right now our Treasury Department is located in that area as well as Inland Revenue. So there needed to be some discussions with the department heads and a clear indication to Cabinet why we were going outside of the central road town district. We also went into the Seacow's Bay area and looked at accommodation that was available there as well.
If you go to page 4, please. The top of the memorandum, you refer to a cabinet decision to give exceptional approval for the Office of the Deputy Governor and the Ministry of Transportation, Works and Utilities in consultation with the Ministry of Finance to make adjustments to leases and to obtain changes in spaces if necessary. with respect to relocating departments from what's now the Honourable Ralph T. O'Neill Administration Complex without having to return to Cabinet for approval. So hitherto, you had to do that, and presumably even in the immediate post-OMA years, you also had to, every time you were renewing a lease or entering into a new lease or varying a lease, you had to return to Cabinet for approval. Is that right?
For the new leases, yes. If there was a change along the way, because we were having such a challenge identifying buildings, we wanted Cabinet to give us a little bit of leverage to make those minor adjustments to the lease rather than having to come back again. So these were for the new leases that we were entering into, yes.
So what did you still have to go to cabinet for?
Initially we had a list, and through the negotiations with the landlords, we found that there was a lot of movement because a lot of trust companies were already in discussion with the landlords, and there was negotiation happening there. And as the government, we had to give them a package that was as attractive. We couldn't do that to the extent that the private sector could. So what we did was to ask Cabinet for just an approval with the relevant bodies involved, the Ministry of Finance, that if we needed to negotiate a little bit upward, then we had the ability to do that rather than coming back into Cabinet.
And do you still have that exceptional approval?
No, because this was just for the buildings that were specific to the central administration building.
I see. And once you resolved that and placed the various departments, you didn't need it anymore?
No, this process is complete. We have submitted a report. We're asked to provide a report on an annual basis. So the movement of offices from the central administration building, that project is now complete.
But in terms of an option that allowed your office to be perhaps more flexible, did you see it as a beneficial step for Cabinet to have taken?
I did, because we were. I think there was one point where we had 4 departments. We just could not find suitable location. There was. If you're not familiar with the spaces, but we actually took warehouses and converted them to become office spaces. And that required a lot of outfitting. But the advantage there was that the cost, the lease amount per square footage was significantly less than what we would have paid within Road Town. So that's why we asked for the Ministry of Finance to be on board, because we were able to demonstrate to them that going outside of the central district, even though we were using buildings that were not the norm, the cost reduction was significant, even when you added the outfitting cost to it.
Do you think as an option, that's something that Cabinet should think about making permanent? Giving because you do it in consultation with the Ministry of Finance, yes, and with another ministry. But in terms of affording the 3 departments or ministries together some flexibility about how they negotiate leases or deal with leases, do you think that there is a valuable lesson there?
If that decision is to be made, I think we will need to have more specific details on the range of costs for specific items. We don't have that written formally and presented to Cabinet. So I would hesitate in us having that overarching ability to do that without a firm agreement on the range of costs for each area that we're engaging within the lease.
Mrs. Stoutt-Igwe, would you have a different view, or would you agree?
I would prefer that the decision making be left with Cabinet on overall. I understand what was done with this because you're dealing with a time frame in terms of trying to get out persons when spaces became available. So I think this was the better thing to do, simply because I know we found ourselves in having to make an adjustment from the Ministry of Education that a decision had already been made, and then we found an additional space. Because an approval had already been given for the space, I didn't see the need to go back to Cabinet. So I was grateful for the opportunity that Cabinet gave to Deputy Governor's office at that time, because it was all around getting departments out of the admin complex. Time was a factor. So I think the ability for the Deputy Governor's Office to have that flexibility so that you can move when properties became available, I think because of the large scale move that you were doing at the time, because of the fact that others are going to be done occasionally, I think the authority should remain with Cabinet.
Now, one of the buildings that was utilised and that you moved into is the RFG building, which I think the Ministry of Finance rented that. And it was 5 years from the 1st of September 2020 was the lease. If we go to page 70 in that BVI file, please.
Sorry, can you clarify the number?
70.
70, thank you.
This is a Ministry of Finance memorandum from the 14th of July 2020. And if you look at, it relates to the use of skeleton bay lot at Fish Bay. But if you go to page 71, what's mentioned is that the Rita Frett's George's building, RFG, was envisioned to house certain departments of the Ministry of Finance, but this is no longer feasible as originally envisioned due to the limited space, ability to service the public effectively, and readiness of the building. So that was the position in July 2020. I just wanted your help with this, because if we go to page 76 in the same bundle, 76, we see that there's then a sublease entered into, which is signed, and we can see that at page 88 in August 2020. Could you just, if you can, just help with this, because we have a lease for the RFG building, a sublease being signed in August 2020, but it's noted in July 2020 that it's not able to support the needs of the Ministry of Finance. Was there any reason that a decision was made to go ahead with it?
Yes, so the RFG building was originally used by the Ministry of Finance to house a number of their departments. The building had extensive damage and we ended the lease. The lease was surrendered. The building, it took some time for the repairs to be completed, and there was a lot of discussion with the landlord about some additional areas that needed to be improved. For instance, the elevator, or installed. I'm not sure whether it was approved or improved or installed. At the time when the social distancing procedures came into effect, we therefore realized that the space in many of the buildings that were originally occupied with departments could no longer work. So the Ministry of Finance needed to have additional space to accommodate their departments. So the ministry of itself, the ministry proper, and some of their key departments that work closely with them would re-enter that building. But the Department of IT and the Inland Revenue Department, which was with that ministry at the time, Department of IT has since moved on to another ministry. But at the time, those departments, the decision was for them not to return to that building, but that we find accommodations at the Skeleton Bay lot. The ministry has since moved into, or they are in the process of moving into, the RFG building. And with that move, they can determine how many of those departments that were not, that are no longer with them, how many of them can actually be accommodated in the RFG building. So that was the reason for us to continue to engage in that lease.
If you go back to 71, please. And this takes us to the point you were referring a few moments ago, Mrs. Dabreo-Lettsome, to Skeleton Bay lot, and that there's a reference to that in the paper, which, and the paper explains that it's going to need retrofitting and outfitting. And the cost of the work is estimated at $621,000 for 3 departments covering 4,000 square feet of space, respectively. What the paper speaks to is a decision being made to waive the tender process for that retrofitting and outfitting exercise. Now, were any alternatives considered in relation to the tender process?
These were the last 4 departments that remained in the central administration buildings. Well, 3 + 1. And it became extremely difficult to find any location. We then had the Ministry of Transportation Works who said to us that we needed to get space for them urgently because the building continued to deteriorate. The central administration building continued to deteriorate. And I think what happened when the works actually started on the central administration building, because of the time frame that was left to start the repairs in that building, they then discovered many other things. So there was an urgency to get departments out of the building. In addition, the works had to start in the administration building while we still had officers there. And there became a major health and safety issue. We had many departments calling. We had departments that could not go to work. We had offices that were closing because the generators didn't come on at some point in time, or the scent of the mold was too strong, the noise was too much. And so we asked Cabinet to allow us to waive the tender to allow for the outfitting of the Skelton Bay lot to take place quickly.
So you could get the last 4 departments.
Exactly, yes.
What is the current state of repairs to the central administration complex?
The roof, the skylight has been replaced. The roofing, I believe, the cladding has been completed. The interior designs are, I would say, maybe about 80%. We've been fully engaged with the ministry that's leading that project. So once the departments exited, we saw a rapid increase in the work that could take place within the building itself.
And which ministry is leading on the project?
The Ministry of Transportation Works and Utilities.
And in terms of your office, how, if at all, does it interact with that process?
We are right at the table with them. There are meetings that are held weekly. We review the designs, we make recommendations on space, we make recommendations on which departments will re-enter the administration building. We're looking at areas of common use of services to allow for easier access by the public. So we are fully engaged.
Could you turn up, please, page 132, please? Again, what I'm moving on to, if I may, is trying to use some examples of leases that you entered into to just, if you can, just explain how the process works and where your office will interact in the process and where you don't interact in the process. If you could keep that in mind, please. So what you have at 132 is a letter to Lake Development Company Limited, dated the 18th of October 2017. And if I think, give some background. So in 2014 and 2015, the government had signed 5-year lease agreements for the 3rd and 6th floors of Cutlass Tower, which is owned by the Lake Development Company Limited. And that space had served as the headquarters of the Virgin Islands Shipping Registry. And of course, the building was, as with so many, damaged in the hurricanes. And what there is here is a letter from the government addressed to Mrs. Patsy Lake as the director of that company. And it's giving written notice of the need to, quote, secure and restore, end quote, the building. So we take it from that in the aftermath of the hurricane, that building was uninhabitable.
The building was damaged, yes.
But you weren't in a position where public officers could actually return to work in that building.
I am going to ask my colleague to take this because I think her memory on this will be much clearer than mine, because this was in 2017.
It was not habitable. The windows were out. Things from the ceilings were showing. It was not habitable.
What the letter speaks to is that it purports to sort of follow up on numerous conversations concerning the need for the lessor to cause the said building to be secured and restored. Would your office, Mrs. Stoutt-Igwe, have been involved in those conversations?
No, those discussions were strictly between the Premier's office and the landlord.
And was it with the Premier office because the Virgin Islands Shipping Registry sat under the Premier's office?
Correct.
And again, using it as an example of process, is this one where the Deputy Governor's office is an optional recourse rather than in any way needing to be involved in such discussions?
If I can just say that after the hurricanes, we had to do an assessment of buildings that have been damaged severely. We had different levels of damages that took place. We had to then determine which offices were able to relocate to those spaces and which we had to find alternative arrangements for. The government's offices, the new central administration complex actually became this building because this is a building from which we operated from certain services. So shipping registry actually was relocated downstairs where we were with the Deputy Governor's office for a couple officers because the spaces were so limited that we only had a fraction of some staff members operating. Some offices were only operating as a fraction. So after we did the assessment, departments were asked to do the assessments based on the premises that they occupied. And there were a couple leases that were damaged depending on the lease arrangements. There were some leases that had already expired. We were probably on a month-to-month basis. There were a couple that we were able to just go ahead and terminate because they were just not going to be habitable. Others, the places were damaged, so departments were in contact with the landlords as to secure the buildings. And then, of course, there were a number of them that had to, because there was no other place to store documents, files, some of their documents remained in the buildings. And then there had to be discussions with the landlords in terms of suspending rent, paying partial rent. Those discussions had to take place after that.
Well, following up on what you say about discussions, if we turn to page 134, we can see there a letter dated the 27th of July 2018 from a lawyer representing Lake Development Company Limited, addressed to the Permanent Secretary in the Premier's office regarding the tenancy of the 3rd and 6th floors of Cutlass Tower. And it points out that, or refers to the letter that we were just looking at, although it gets the date wrong, but presumably you would not, as the Deputy Governor's office, have been privy to any correspondence or discussion that was going on between the Premier's office and the landlord.
Not at that time. I think we might have been copied later on. We were copied on the letter, the October 18th letter, 2017. I don't see any indication that we were copied on the one from the lawyer in 2018.
No, but what appears to be the case from the letter is that the landlord points out that the landlord hasn't received any rent payment for almost 10 months. And that the Virgin Islands Shipping Registry had moved out of the building and indeed moved into another location. But what at 135 we have is the point is made that the government has retained the keys. Employees have continued to access the building on a daily basis to retrieve files and documents. And therefore some rent was due. And the proposal that was made was to pay for the first 3 months after the hurricane 50% and thereafter 75%. In terms of resolving that issue, did your office become involved at all?
Yes, we did. It was brought to our attention And I think because shipping registry by that time, yes, they were occupying a different building and had been asking to enter into a new lease arrangement with another landlord. And I think we had asked them to settle the matter where they were before, because we were not prepared to advance another request for government to be paying rent at 2 different locations. So we had asked them to sort out that matter, to look for an alternative site where they could then move their files to, so that they could conclude that arrangement over there.
Now, obviously, the dimension to all of this is the hurricanes.
Yes.
And the circumstances in which you and so many public officers would have been working under. But stepping back from that, where we see a sort of example, if you like, where there is what might be described as a dispute over rent between landlord and the government department. Again, taking it back to process, is that the sort of thing that the Deputy Governor's Office would routinely expect to become involved in?
Not necessarily, because if there's a dispute, that's where we turn to once you start having lawyers writing letters, it's time to engage the Attorney General's chambers. So that's usually a recommendation. Make sure you get chambers, inform chambers as early as possible in the process. But that was not a direct role of the Deputy Governor's Office. Our role comes in with negotiating for making arrangements and recommendations for OAC, but that was not a matter for the OAC at that time.
So you're not although it may be that departments might come to you for guidance, that's not your role. So where there is a dispute, a department might choose to solve it, but what the advice that you would give is get the Attorney General's chambers
Attorney
involved.
General, because we are not the legal experts, and we were not prepared to be the referee in a case like this.
If we turn up page 141.
Okay.
What then happens in relation to at least the tenancy of the 3rd floor is that the Permanent Secretary at the Premier's office on the 6th of November 2018 gives notice in relation to the lease of the 3rd floor, and that it shall end in accordance with the lease. And your department is copied into that. Who would have made that decision to terminate the lease?
Who wrote the letter?
Right. So I mean, would it have come on the heels of your office saying we can't justify paying for 2 buildings?
Yes, and because we know that the matter was outstanding and they still had files and other things, and we know that they were trying to access the building, we did ask them. We had written to them a couple of times saying to them, bring this matter to conclusion, because it's getting a little bit, the waters were beginning to get a little bit muddy. So we did ask them to try to make a decision, especially because of the fact that the lawyers had already written about the matter. It was time to bring it to conclusion.
See, well, I think we can see that if we turn up to page 142, because this is a memorandum from the Permanent Secretary in the Premier's office to the Permanent Secretary in the Deputy Governor's office, dated the 8th of November 2018. And it sets out some of the history. And it's quite clear that by now, at least your office is involved, or certainly aware of what's going on, because there's reference made to the Deputy Governor's memorandum of the 6th of November 2018, and circumstances whereby the landlord has seen it fitting to use the media to express justification for the payment of rent she believes is owed, and to disparage the reputation of the government. The Premier's office deems it of utmost importance that in government, the time is taken to assess the best approach to addressing this matter, and to stand as one government in speaking to not only the landlord, but the public as deemed necessary. It then sets out the circumstances in which, by reference to the hurricanes of 2017, a decision was taken to suspend rental payments from the Virgin Islands Shipping Registry in full, as opposed to partially. And it then continues, if we go to 143, of that in relation to the ongoing tenancy, if you like, because what's noted is that the damage caused by the hurricanes might cost the government some $150,000 to rebuild the offices in the Cutlass Tower so that the Virgin Islands Shipping Registry could actually return there. And there is a discussion, a reference to a meeting with the Premier's office and the Attorney General's chambers to meet with the landlord on the 9th of November 2018 to negotiate the proposal for rent payment claimed by the landlord. And that's reference. And it says there's an invitation to the Permanent Secretary Deputy Governor's Office remains extended. Did anyone from your office or yourself accept that invitation and attend?
I know that I did not attend. I believe that, I'm not sure, I do not recall which specific meeting. I know that we were represented at meetings and some on-site visits, but I do not want to speculate about this specific one because it carries a specific date. So I cannot speak to whether or not we were represented at this particular meeting. This letter was dated the 8th and the meeting was the 9th. So could it be received on the 6th? Unless something seems to be going on with these dates here because the received sample size dated 6. That's dated the 8th. So I can't speak to whether or not somebody attended this particular meeting, but I know that they had made requests for meetings, but I know I personally did not attend.
I apologize if I'm repeating the question, but just trying to understand how the DGO, the Deputy Governor's Office, comes into play. I mean, is this an example where a department could decide that it doesn't need your presence, so that they could decide that when they're negotiating with the landlord for whatever reason, and it could be, if you like, a non-hurricane related reason, because obviously that added an entirely different dimension, but the relevant department could engage with the landlord and with the assistance of the Attorney General's chambers, and could decide not to keep your office updated at all.
I think the Deputy Governor's Office needs to know the outcome more so than the process. Because at the end of the day, the department is a tenant, not the Deputy Governor's Office.
Your role is to oversight of the lease management process.
Right. So not for example, if something is wrong with the building, you have a leak or whatever, that's not something that needs to come to us. The tenant needs to deal with that on the landlord. So if there's a dispute, they deal with the landlord. So there wasn't any need for us to be leading these negotiations because it was between the Premier's office and the landlord that had the discussions. So we were there basically for information purposes.
But if we use an example of where you might be involved, if I give you this example, if for example, there was an infestation in a government office such that all officers had to be relocated to a new building, or there was an environmental health issue that meant that officers couldn't continue to work safely in a building, is that the sort of situation where the government department would have to involve your office?
The Deputy Governor's Office should be involved because the Deputy Governor's Office basically is in charge of the public service on behalf of the governor. So just like we have, if a department has to close for whatever reason, the Deputy Governor has to be informed and give consent before that office closes. So it would be the same thing.
But also if the government department can go and find new accommodation, but they would have to go through the process that Mrs. Dabreo-Lettsome outlined.
Right. They
can
identify, but not
recommend.
Right. They can identify and make the recommendation, but not go and find to move.
If you turn up 165, please. you were, at least in this instance, kept up to date, because we have a memorandum from the Permanent Secretary, the Acting Permanent Secretary in the Premier's office, to the Permanent Secretary in the Deputy Governor's office yourself, dated the 25th of March, which explains that the circumstances, and that that there had been correspondence. But the situation takes a turn in that the current lease with the shipping registry expired on the 31st of March 2019, but there was then a decision that because although the Virgin Islands shipping registry wasn't going to return to Cutler's Tower, it was seen as a viable option for the Premier's office and the new appointment of 2 junior ministers. And so the decision then was taken that the space that was vacated by the shipping registry was going to be taken over by I think the junior ministers and the Premier's office. So does that then start off a new round where you're now having to start off negotiations?
No, they would start the negotiations. So I think there was also correspondence where you would have seen that after that came, we would have written to ask for the information, because we had just come through with terminating that, and that was in March 2019 when we got that instruction. But any negotiation would have had to be done and then submitted to us, because it would then have to go back to the Office Accommodation Committee, because it would not be considered like if it was a renewal. But because of this here, that was going to have to come back with all the relevant details, just like it's a brand new.
Because it's a different government department entering into a lease.
Yes, as well as different, I'm not sure if the space was the same, or yes, different government departments, as well as the fact that it's a brand new lease. So this is a totally new arrangement, so they have to go through the same process that PS Dabreo outlined earlier.
Now, at 165 in the bundle, there's email exchanges, but the position seemed to be reached in what I think is May 2019, is that there was so you had a situation where one department, Premier's office and the junior ministers, wanted to move into the Cutler's Tower. You also had an ongoing dispute in that there was a dispute over the repair of partitions that had been put up by the Virgin Islands Shipping Registry, and the landlord was demanding just under $23,000 to make good the repairs. Do you know how that was ultimately resolved, or would that not have been a matter that would have come to your office?
I'm not sure how it was resolved, but eventually the Premier's office is occupying that space. So I'm assuming that the government would have probably fixed it, because if they wanted to occupy, because I think basically what the landlord was saying is that I think she was responsible for the AC unit, but the petitions had been put up by the government, and since they were damaged, the government, in order for her to repair the AC unit, the government would have needed to put back in the petitions. So I guess it was resolved when the Premier's office eventually took over the space.
This is going to sound very much like a layman's question, but the sort of chronology of the Premier's office taking over the 3rd and 6th floors of Cutler's Tower is that, as we've seen, there was an intention communicated to your office that those departments would like to take over some space. There appears to have been an issue over when the date was going to commence, in that the landlord wanted a particular commencement date, which the government wasn't willing to agree to. I can take you to the papers if you need to be reminded, but I'm just going to try and encapsulate this. the then next step was that the Deputy Governor's Office draws up the leases. It then goes to Cabinet to authorise, which Cabinet did do on the 2nd of October 2019, and that was for accommodation for the Office of the Premier and the junior ministers. But what you have is you have leases signed on the 20th of March 2020, but with a commencement date of the 1st of July 2019 for the 3rd floor and 1st of August 2019 for the 6th floor. And the spaces are then occupied, I think, till just mid-June 2020. Can you just explain, just without getting into the detail of this, but how does that work? How is it that government has to sign leases which actually have a start date that predate the signing of the lease?
So you need to take me to those pages.
Right, okay. If you go, please, to 195, please.
195.
Yeah. Sorry, it's give me one moment. Sorry, we've got so we've looked at 164, where the on the 25th of March, there's an expression of interest, if you like, communicated to your office. Look at in the bundle, page 20.
Page 20. Page 20, you refer to an email from?
Yes, but what that email says is that this is the point that the negotiations start. So there's an issue over the start date of the lease. So this is a 9th of January 2020 email, and the proposal is that the 3rd floor space would be in effect from July 2019.
From the time you're talking anything beyond September 2019.
I see, of course, right, you pass over. That's fair enough.
My colleague here.
All right, I'll start again with Mrs. Dabreo-Lettsome. So you have, and I can take you to it, but I have 25th of March, there's 2019, there's an indication that other government departments want to take over space in Cutlass Tower. The email by which time Mrs. Stoutt-Igwe has moved to a new role, and you are now permanent secretary, is the point at which there's discussions over the lease. And so what we have is that although it's an email of the 9th of January 2020, the landlord is proposing a start date of July 2019 and August 2019. You then, if we go to 194, have the communication of a cabinet decision. And if you look at A and B, Cabinet has decided on the 2nd of October 2019 to enter into a lease for the 3rd floor of Cutlass Tower and enter into a lease for the 6th floor of Cutlass Tower. And it gives the rates and for per square footage plus the monthly service fee. So what you have is you have by this time what must be the recommendation that has come from the Office of Accommodation Committee, the Office of Accommodation Committee, in that you have proposed rates which presumably flow from negotiation with the landlord and the cost. The leases themselves, if you go to 207, if you first turn up 201, We've only got one of the leases, Mrs. Dabreo-Lettsome, which relates to the 6th floor. So, but that tells us that, or page 207 tells us that the lease itself was signed on the 20th of March. But the space itself is not occupied because you provided a press release, I think, or press bulletin at 214, which tells us that the Premier's office will be able to resume its operations at Cutlass Tower from June 15th. So that's the background. So it's just trying to understand that you have a request in March 2019 that comes into your office. The process takes us through to June 2020 when the government department can actually move in. So first of all, taking it generally, what you have is leases, a lease being signed in March 2020, but with an earlier start date. So is that the way it normally works?
Not usually. This was very different because Stoutt-Igwe has taken you through the challenges that occurred between the Premier's office and the landlord. The fact that the shipping registry was still occupying a portion of the building for storage, even though they had relocated. And the communication that you have shows the issues between the landlord, her legal representative, and the Premier's office. By the time it came to us, we needed to have an understanding of when that negotiation started and what date was discussed with the landlord to have the occupancy of the building begin. And from the process, I said to you that the departments have to indicate that occupancy date before the lease is sent on to the Attorney General's chambers. So we pressed several times to receive a date when the lease should start. And there was some negotiations back and forth between the landlord and the Premier's office on what would be the acceptable date to start the lease, considering that portions of the building was in fact occupied and still occupied with storage from shipping registry. I don't remember when that actually ended. So we got instructions from the Premier's office to Mrs. Seymour, Helen Seymour, who was the Deputy Secretary at the time, to say that they had agreed. They proposed one date, which the landlord did not accept because she said that was not the date that the negotiation started. That was not the commitment date that she understood as being the time when the ministry wanted the space. So she took her property off the market and reserved it for the government. But it took some time to deal with the dispute that was happening between the two permanent secretaries in the Premier's office and then getting back to us. So we needed to rely on what the Premier's office was able to finance and what their discussions, what the outcome of their discussions was with that landlord. And they communicated to us that they had accepted the July and the August as the start dates for each of those leases for each floor.
Take it back to the role that the Deputy Governor's Office has in terms of recommending. So for example, as I understand it, you can refuse to, as Mrs. Stoutt-Igwe said, you can refuse to advance a request to the committee if, for example, a government department comes to you and says, we have decided to, or we would like to rent this building, but it's at a rate that's above the rate that government will accept. Here you have a government department requesting or expressing an interest to move into a particular building, but what, and you could presumably have said, we won't advance it because you're going to pay too high per square footage. But why can't you say the same thing in terms of the start date of the lease? Is it down to the department to agree when the lease will start?
We had instructions to surrender the lease, which is what you presented earlier. So the surrender to lease process had actually started. So there was not an intention that we were going to re-engage the landlord. what we discovered is that there were discussions taking place with the landlord. And as Stoutt-Igwe said, we were not part of that discussion until later on we were invited to the meeting, and she's indicated that she didn't recall attending that meeting. I'm not sure if we have records that we attended actually, but what happened is you had a situation where there was an ongoing dispute without our involvement. By the time we were given instructions to say, we're not going to surrender, we are going to engage a new lease, we went through the surrender process to end the existing lease and to engage a new lease. But we also had further communication from the Premier's office to say that yes, they had discussion with this landlord with a commitment the year before. And she has rightfully said, I've taken it off the market and you've stopped me from getting rent, and therefore you need to commit to the dates.
I see.
And I think at that time our hands were tied because there was clear communication and clear evidence that that discussion was taking place at that point in time.
So the Premier's office had agreed in this situation to a particular start date.
Correct, yes.
But it's just taking it back to the process. It's just trying to ask you how it works. So in this situation, you had two things going on.
Yes.
You had one department that post-hurricane had used their space to store, and therefore there was an issue with the landlord about paying some portion of rent, which was resolved in one way. You then had a separate department expressing interest to use that building for its own purposes and starting a new lease process. But just speaking, it's just keeping it general. You can refuse to advance in the normal course of events. Would it be down to your department, to your office, and then the Office Accommodation Committee to advise as to the the start date of a lease?
We would recommend what time frame we would need to outfit or to address any outstanding matters to allow for that lease to take place. Normally, we would be part of that discussion.
And normally, I think you sort of suggested that a start date for the lease, which predates the date on which you sign the lease, is unusual.
Yes.
And in this instance, I think you've explained that there was obviously discussions between the Premier's office and the landlord, and the Premier's office accepted the landlord's argument that a loss had been sustained because the property had been reserved for government. But is the normal approach to sign the lease and have a start date when government is ready to bring in contractors to retrofit and outfit a building?
Sorry, can you say that again?
What criteria do you use to pick or to recommend the start date for the lease?
The start date is usually at the time when, I think it's what you said, when the government feels that we would like to enter the building and start to change the layout of the building to accommodate the departments that are going in. That's usually the start date. So therefore you see sometimes the lease is started and then there's an outfitting period of a few months before you actually see physical movement into the building.
So in this situation, there would have been it's unusual because you're paying rent for a period of time when the building can't be used other than for storage, and then once you sign the lease, that's when you can get into the building to retrofit it.
Correct.
Which explains the time gap between signing the lease and government departments actually being able to move in.
Yes.
I think I'm still with you, Mrs. Dabreo-Lettsome, because if I could just ask you to look at page 220 in the bundle. I can take you to a document that if you need it, that helps with the timeline. But as we understand it from the papers that have been disclosed to the Commission, on the 27th of May 2019, space on the second floor of Cutler's Power was requested, and that was for the Ministry of Finance. And that was brought to Cabinet and authorised on the 7th of November 2019. Now, if you look here, you've got a memorandum from the Financial Secretary to yourself, dated the 22nd July 2020, which begins that writing to a long outstanding matter, and says that the Ministry of Finance will take up space, provided that various repairs are made. And if those aren't done, then the Ministry will not engage in any lease. You then, I think, if we go to 221, wrote to the landlord, identifying the issues that needed to be addressed. And then you conducted a site visit, because we see that at 224, items that needed remedying were identified. The Ministry of Finance told you, and we see this at 245, that the ministry still wanted to use the space. And we have if you go to 247, you have a lease entered into, which in fact was signed on the 13th of October 2020. You can see that it's stamped exempt from tax duty on the 27th of October. But the lease was scheduled to run from the 1st of January 2020. You can see that on the front page of 27. Now, what that points to is that you have a space that's brought to Cabinet and authorised in November 2019, at a time when there are significant problems and a question mark over whether it could be used, because there's still work that's to be done. And after that date, the Ministry of Finance still raises a question about whether it will want to use that space. Now, looking back at the process, why would a space which couldn't be used be recommended to Cabinet?
This obviously has taken trends that are far away from the normal process. And again, I go back to the fact that a lot of the discussion and negotiation happened between the department and the landlord, things that would normally have taken place with the department and ourselves and the landlord. And in the absence of our involvement, we really had to take instructions from the ministry, as they were the ones who started the initial negotiations with this landlord in particular. It is not a norm for us to recommend a building that has challenges for government to engage. There was a challenge with this particular arrangement. I think there was a breakdown in communication at several points in the process. And the fact that we were brought in, as Stoutt-Igwe had indicated, we were brought in at a later date. We had basically the only opportunity we had presented to us was to clean up the situation and to allow for us to engage the landlord to address what you would call the building retrofitting or the building repair issues that were there, to allow them to move in.
So would it be fair to describe the situations we've just gone through, the two situations, as outliers for the normal course of events? Usually you would be expecting to be recommending at a point in the process where a building is good to go, so to speak.
Yes.
And just remind me of this. I mean, if you make a recommendation and it goes through the process and Cabinet accepts it, once Cabinet accepts it, does everything else then flow? I mean, do you then, does your office then draw up the lease, it gets signed?
Yes.
Is there any point after Cabinet?
So is going to affect our ability to occupy the building. We will take the matter back to Cabinet.
Now, if I move on just to the Virgin Islands Shipping Registry quickly, and I can take you to some documents if you need to be reminded of the dates, but I think this is, again, it's directed towards Mrs. Stoutt-Igwe. Although I think my ability with dates might mean that the file moves back across. But again, we've spoken about the Virgin Islands Shipping Registry having to leave Cutlass Tower, and as we understand it from the papers, they then moved to the RGH Plaza on a month-by-month tenancy.
Correct.
If you go, and I think it's actually the Mr. Frett's affidavit. Now, this is, if you go to page 12, please.
Okay.
This is a Cabinet paper, so it comes from the Ministry of Finance, and what Cabinet is being asked to do is agree that the Virgin Islands Shipping Registry will have accommodation in
report, you said?
Good.
So it is yours.
Mr. Peters, we're ready to resume our live stream.
Oh, okay.
Good. Thank you, Mr. Rice.
Thank you, Commissioner. I think we were with Mrs. Stoutt-Igwe. And Mrs. Stoutt-Igwe, I was showing you a cabinet memorandum from the 12th of April 2018, and you confirmed that on page 14 that the date should have been 16th of March 2018. And what more importantly, the memorandum says is that the matter being the Virgin Island shipping registry being located at RG Hodge Plaza on a month-by-month basis was discussed and approved at the Office Accommodation Committee meeting. Now, can you remember being the first sort of involvement of either the Deputy Governor's Office or the Office Accommodation Committee in where Virgin Island Shipping Registry was located?
Can you repeat your question?
We have a situation where post-Irma, the registry has to move, and it moves to RG Hodge Plaza, and it's on a month-by-month tenancy. Cabinet is proposed to Cabinet that arrangement needs to be authorised by Cabinet, and it says the matter was discussed and approved at the Office Accommodation Committee meeting. So would I be right to assume that what the Office Accommodation Committee meeting would have approved is the registry continuing a temporary lease arrangement?
Yes.
And do you remember whether prior to that, as the Deputy Governor's Office, you were aware of the arrangements that the registry had entered into?
We were aware that they were in the new location, would have been months before. Let me see, let me refer to my notes here, because which one of these documents has in 462? It's probably this one. The background for that relocation can be found on $462 in this bundle.
So that's in the larger lever arch bundle.
So if you look at the background there, it tells you that they were located at Cutlass Towers. As a result, they had to seek alternative arrangements, accommodation. And at that time, there was a shipping company that relocated from RG Hodge Plaza that allowed them to utilize the space until the end of their lease term. And so that is when they started to occupy that space. So when the lease term had expired, it was at that point that prior to that they wanted to make arrangements to make the lease permanent on a month-to-month basis. So we were aware that they had been occupying that space because they were granted, they were given a space that they were not paying for at the time because somebody had moved out, a company had moved out and allowed them to stay there.
So they took over someone's lease,
right,
and then continued on a month-by-month basis.
Right, so we were aware of that because initially they were being housed in this building, but the space that was downstairs in the FIA. Oh, sorry. The space could only accommodate a couple of the staff members. So while some of the members were housed here, some of them were housed in this RG building. So we know that they had to look for alternative, and based on the work that they do, they had to continue their operation. So we know that the Deputy Governor's Office was aware that they were located in this space because we were keeping a record as we were restoring services, we had to keep a constant record as to where offices were located and where they were moving to. So we were aware.
I think if you turn back to page 150
of Mr. Frett's.
not Mr. Frett, of the main bundle, please.
150.
Yes, that's a memo from yourself to the Permanent Secretary in the Premier's office on the 8th of December 2018.
This one here.
Yes.
Okay, that's a memo.
Yeah.
December.
Yeah,
Okay.
2018. So if you go to 151, we'll see your signature, and you point out that the registry had occupied space in RG Hodge Plaza for over a year without the permission of Cabinet and without a lease instrument to guide the relationship between government and the landlord. And you ask for action to be taken. So that would seem to be the prompt for what then follows, which is that a recommendation is put to Cabinet for the registry to continue on a month-by-month basis. And if we see at 158.
That's not my signature, but I was aware.
Yeah,
Okay.
I mean, I think it's PP, isn't it?
Yeah. The Deputy Secretary signed for me, but I was aware.
Yeah.
What's the page you're referring to now?
158, please.
Okay.
What then happens is that Cabinet does authorise the leasing of initially the second floor from the 1st of December, and it's backdated to the 1st of December 2017. And then on the 25th of February, as we see there, Cabinet authorised the lease of a second floor RG Hodge.
Right, because the second space was to accommodate the storage of the files, which were housed at Cutlass Tower.
And which had to be moved out.
Yes.
Yeah. But if you could just go to 226 in the bundle.
August 17, 2020.
Yep, and we go back to Mrs. Dabreo-Lettsome. So what we have, Mrs. Dabreo-Lettsome, and I can ask this question, and either one of you might be able to answer. But we have a situation whereby you've had for good reason the registries had to move out. It's as Mrs. Stoutt-Igwe explained, it takes over a lease, then it continues on a month-by-month basis, which is retrospectively authorised by Cabinet. Now, you spoke at the beginning about how sometimes that is an arrangement that government will enter into. In terms of the balance that you have of leases, where you have leases for long periods of time, and leave aside housing, which might be a different question. But in terms of the balance between leases on a month-by-month basis for office accommodation and a long-term basis, where does it fall?
The month-by-month would be in those situations, those circumstances where you know it's not, you don't want to enter into something more permanent because it might be some reason you get there temporarily because you know that they're likely to move someplace else. So, and then also it could be a situation where it's not the ideal situation, like after the hurricanes, some accommodation were not the most ideal, but you basically had to take what you got at the moment. So you don't want to get into a longer term arrangement if you know it's not really satisfying the needs of the agency, but you just need to get some place for them to occupy in the interim. So ordinarily, it will be a longer term lease. Usually I would say the average, probably about 3 to 5 years. Especially if you know, like for example, those offices that would have moved out of the admin complex, we try not to get into not too long leases for those, because we know we had the we know we're going to go back into the complex. It's turning out that some of those that should have been a little longer, we're going to have to extend them because we thought that the process would have been completed within a 3-year period, but we're now in 2021. So certainly those that we know, there were some offices that we identified that once you're getting ready to move back into the complex, there are some offices that might not need to go back into the complex. So those you had a longer term lease looking at. But I think we've been averaging 2 to 3 years based on the fact that you're going to go back to the complex. But month to month, it has to be those that are month to month because you know that it's just temporary and that change is likely to happen within a short time frame.
And therefore, can it be safely said that the position of the registry was unusual and essentially a consequence of
shipping registry?
Yeah.
Yes, I would say so. That was one of the unusual things. And I think because of the fact that they were going month to month at the time because of the uncertainty as to whether or not, because at one point there was talk about going back to the Cutlass Tower. So I think the uncertainty at that time, you weren't, because you already had an existing lease, you just couldn't go and try to get a new lease for long term. So I think if ideally they would have preferred to go back there, but then there was some cost savings over in the other building as well. So
because we didn't say it, but one of the documents that in fact, the document that you took us to refers to the rent that the shipping registry had
yes.
at RG Hodge Plaza was a reduced rent.
Reduced rent, yes. While it's ideal sometimes to have everybody in one location, the other location didn't provide that for them to all be on the same space. But at least it was close enough for them to operate.
But you're as permanent secretaries in the Deputy Governor's office, you're in the unusual situation because, in fact, what one would call the normal process has got to be seen through the lens of the hurricanes.
Yes, certainly the hurricanes put a different spin on everything where it relates to accommodation, because I think since the hurricanes, we've been just juggling offices all the time. And then we try to accommodate as many as we could outside it, within the complex, but then by the time the complex came to start being repaired, that was another juggling act again. So everything has basically changed drastically since the hurricanes.
And so a situation where you have a government department on a month-by-month tenancy, which actually runs for a significant period of time, is not the norm.
No, definitely not the norm.
And Mrs. Dabreo-Lettsome, you spoke earlier of the intention of government is to reduce the number of leases it has. Would it be fair to assume that pivotal to that would be the restoration of the central administration complex?
That's correct, yes.
And in terms of once that is up and running, how many departments or ministries would you expect to see back in that building?
All the ministries will return, and we will have about 4 or 5 departments that will return, because those are the ones that will be front-facing departments. And we will also have a few other, maybe 2 or 3 others that can fit into the space. But in terms of your question about month to month, as I mentioned before, I'm aware of one particular situation where we are on a month to month because the landlord needs to address some matters with the building before we enter into a long-term lease. But it is not our practice to have month-to-month arrangements with any landlord.
And even where you do you still operate the rate cap?
Yes, we do, definitely.
I am still on the shipping registry, but we've moved forward in time. So Mr. Stoutt-Igwe has moved elsewhere in the public service, and you're now permanent secretary. So the situation we found ourselves in was that I think ultimately, and we can see this at page 175 if you need it, the registry entered into a proper lease agreement. And the example I'm going to take you is that at 175, we see that there's a 2-year lease agreement signed on the 9th of September 2019 between Bargain Centre Company Limited and the government, which is to take over the third floor space of RG Hodge Plaza. Now, that's September 2019. If you go to 226, there is a longish paper from the then director of the shipping registry to, and it would be to you as permanent secretary in the deputy governor's office, and it's about a relocation to Ritter House, which actually is what happened. They're back downstairs. But the point that's made by the director was that RG Hodge Plaza wasn't suitable for the Virgin Islands Shipping Registry. And it wasn't suitable, firstly, because the nature of the clients that the registry has to deal with. It wasn't suitable from a, I think just a sort of in terms of configuration, and what's made, the point is made at page 228, that to refit the accommodation to fit the needs of the Virgin Islands Shipping Registry would actually require immediate funding of in excess of $250,000 or perhaps more. And there's also reference, and this is at 227, to additional environmental issues relating to the building that continue to impact staff members. And all of these are reasons given in advance for the need to move to a new building. But it's less than a year into the 2-year lease. Do you know why? In September 2019, the third floor must have been deemed suitable for the needs of the shipping registry, and now in August 2020, it's been found not to be. Can you shed any light onto why it was deemed suitable in the first place?
The shipping registry at the time, the nature of their job has to do with the inspection of vessels, so there's a lot of movement with the staff. But I think what has caused the need for this is because through the III code and the audit that was done recently, there is a need for the shipping registry to have what you call a call center, a command center for maritime operations, search and rescue operations. And we looked at the option to integrate that into the Office of the Department of Disaster Management, because that department, there's actually an NEOC building being constructed to accommodate that. What came out of the audit is that there was not an opportunity to blend the command center for the NEOC with the search and rescue operations that need to be controlled by the Virgin Islands Shipping Registry. So in order to meet the audit requirements, they're going to have bigger accommodations to install that command center that needs 24-hour monitoring. And so the discussions with them started in that regard. We did try several options to not have to engage in this additional expenditure, but unfortunately the requirements under the MCA audit is not going to allow for blending of those command systems with another department.
As I said, the lease arrangement, the lease agreement was actually signed by obviously the Premier on the basis that all leases are signed by the Premier, and it was with Bargain Centre Company Limited. But it was then discovered post signing of the lease that actually Bargain Centre was leasing the property from another person, and that then had to be resolved. So that takes me to a more general question, which is that when you are looking at landlords as part of your process, what due diligence do you do on the landlord?
There is a check that is done at the land registry to determine whose names are on the deed or the documentation for the land. If the landlord's name is not there, they will have to get a no objection letter to allow them to continue to engage. There's also checks that's done at Inland Revenue to ensure that they're in compliance with the standard taxes and so forth. If they're not, then they will have to settle those before the lease is signed. I think those are really the main ones. It's land registry and Inland Revenue.
I mean, in this case, there was clearly an issue because, and you can, if you turn up page 192, you'll see what's said there. Because it was an issue over land taxes, it looks like. And so the lot was, as said, it's owned by another person, which and it's put to government that the proper search would have revealed this, and Bargain Centre Company Limited has a 30-year lease, but not dealing with this particular circumstances. But will you ask, I mean, we've seen in the papers that sometimes you obtain certificates of good standing, and is that, so do you have, as you've explained that you have inspection checklists, do you have a checklist for that of what you need to obtain to show in effect to kind of do an audit of the prospective landlord?
Yes, those are records that have to come in, and it's part of the procedures as well.
Now, once you have, if some landlords may rent more than one building to you, or you may have a situation, as happened with Lake Development Company Limited, where there is a long-standing relationship between that landlord and government, and there is back and forth in terms of departments moving in and out. I mean, does your system operate on the basis that irrespective of who the landlord is, you will do the checks every single time? Or do you say, well, actually, we've already got the documents on file in relation to that landlord, so we don't need to repeat the process again? No,
every time there's a new lease, the process is followed. We ask for the documents. We treat it as if it's the first time we're seeing it.
And this is, again, keeping it to process, but you've spoken of the rate cap that you will use. And it's going back to the work of perhaps not just of the Deputy Governor's Office, but also of the Office Accommodation Committee. But what criteria do you use to assess value for money?
We have looked at the market value. We have examined the government's ability to pay as part of that process. We've also looked at trends. And I think that reference that you were trying to look for earlier has to do with the referencing and the cross-checking that we do at the end of the year. So there are some leases that are paid by departments directly and not from our office. Our office covers most of them. But there are some offices that pay the lease amounts directly to the landlord. So we reconcile at that point in time, and we undertake an assessment of where we are. So I would say, for instance, the analysis that was done in 2016 indicated at the time we were spending about $6 million in office accommodation. In 2020, that figure, the commitments went up a little bit, but the actuals went down. So then we use those records to determine, are we paying less? Are these buildings that we have now engaged, is the square footage less why the amounts are coming down? Or is it that we took a longer time to engage? So by December, you were not committing, you were not paying the funding that you were actually going to be, I sort of messed that up. So by December, you're going to determine whether the difference between the commitments and the actuals is because you haven't occupied a building as yet and you haven't started to pay, or has it really been that you've made an effort to decrease your expenditure? So those are checks that are done at the end of the year, but it takes some time because, as I mentioned, all of the financing is not with us. So it is a physical call and then waiting for reports to come in. And that's one of the reasons why we've asked for funding to create a database so that any lease amount, whether it's paid by us or not, can be entered into that database, and we have a better ability to do a quick analysis.
And taking about value for money, it's the point that Mrs. Stoutt-Igwe made that what is now a suitable building would be measured in a different way than it was perhaps 20 years ago.
Yes.
There may be a need to have more than one access point. There may be a need to cater for those with different needs. Do criteria like that factor into any assessment of whether a lease gives you value for money?
We look at the building standards. So after the hurricane, we required the certificates of occupancy to be presented. In my position as director at the Department of Disaster Management, I sat on the Planning Authority for many years. The certificate of occupancy is something that is required as part of the legislation, but that aspect of it was not enforced as it should for many, many years. What we did as government following the impacts from Irma was to ensure that any lease that was being signed with a landlord that had a damaged building, mostly all of them, that certificate of occupancy was produced. So that ensured that they were in compliance with the regulations, because in the procedures itself, it says that government should not engage a landlord unless it is an authorized development through the planning authority. So there was an opportunity for landlords to be able to access that certificate of occupancy.
And do you have I'm focusing on office accommodation, but do you have a sort of, if you like, a kind of a list of suitable buildings that I mean, obviously landlords can rent to whoever they want, but the buildings, would you keep a record of buildings that meet standards?
Yes, we do. And we also keep a record of the ones that are not appropriate, that we've had challenges with before. And at certain intervals, we will reach out to those particular landlords to say, how are things going with your development? Are you looking to come back on stream? Because we do have some that we had a very good relationship, very good amount that we were paying for in terms of square footage. The square footage was quite low at the time, and obviously it was attractive for us to re-engage them. But for financial reasons and other reasons, some of those landlords have not been able to come back to restore their buildings. So we do have a list. It's the same thing for the judges' accommodations. We do have a list. We do reach out to the real estate companies, but we try to secure our own listing that meets the range that we are allowed to rent for.
Well, if I come on to accommodation, I had a good few questions about accommodation, but I'm going to try and cut it short. And just, it's again, just firstly, you've told us that when you're looking at needing accommodation, it will go through the same process as if it were office accommodation. Now,
are you talking about houses?
Houses, yeah, housing.
That is even more extensive in terms of the search.
But and again, a factor might be that you might need the housing for a short period of time sometimes.
Yes.
For, certainly a shorter period of time than you would envisage for office accommodation. But again, what standards do you firstly, how do you source your properties? Where will you get appropriate housing from?
We go to the real estate companies as a start. We do keep our own list. We spend a lot of time on social media under something called BVI Apartments, where lots of real estate companies as well as locals would place their homes. Obviously, there's a difference if you're renting from a real estate versus renting directly from the landlord. So we look at where we can get value for money in that regard. We've also looked at patterns, the history of our relationship with certain landlords. Judges are very particular, and the standards from the Eastern Caribbean Supreme Court, as Stoutt-Igwe say, are very, very stringent. We have to make sure that those are followed very closely. And sometimes there is a level of negotiation that has to take place between the judges and ourselves to determine whether this is in fact what they want and where they want to be living. We have 2 commercial judges and 2 criminal court judges that are resident judges. So those will be lease arrangements that will be extended for a period of time. And then we also have judges that will come in at intervals. We have individuals that will come in to work with the police department over time. So you've seen short-term rental arrangements on a month-to-month basis to facilitate their stay here as well.
And again, do you operate a cap in terms of what rent you will be willing to pay?
Yes.
And how does that compare to the market?
It is a bit lower than the market, but I think it is an appropriate amount that allows us to get the right accommodation based on our history of payments.
And the accommodation, the housing you might need to seek is not just for judges, but possibly teachers.
Yes, so there is, it depends.
Police officers,
yes.
Just those inspectors and chief inspector,
Yeah.
just for police.
Yes.
Yeah, basically.
And again, do you
you
have standards? I know the Eastern Caribbean Supreme Court may have its own, but do you also, in terms of your own standards of what's appropriate accommodation, do you have those as well?
There's some
for the teachers?
Or just generally for your housing accommodation?
There are some basic requirements that we look for, but it's definitely not as detailed as you would have for the judges. And we spend a lot of time looking at what's available because we've had some challenges with some of the accommodations for teachers and police officers in the past, fire officers as well. But it's not as detailed, but there are guidelines that we follow.
Thank you.
And the difference is for the judges, we rent a house versus for teachers and others, we rent an apartment.
Thank you. Commissioner, I've reached the end of my questions. Can I conclude by thanking both Mrs. Stoutt-Igwe and Mrs. Dabreo-Lettsome for coming to give evidence today, and actually being the question of how the process works is difficult to follow from a standing start, and they have been enormously helpful in clarifying some of the details. And thank you very much for the way you've given your evidence.
Yes, can I echo that? Thank you for your time. The way in which you've given your evidence, which has been very helpful and if I might say so, very knowledgeable, and it has shed light on a process that was not lit before you gave oral evidence, if I can put it that way. What would be helpful to me, but purely for information, the process map was enormously helpful, because I'm not sure that I would have got through this without the process map. It was very, very helpful. But that, as I understand it, is supported by a number of checklists. I think you said 11 checklists.
Yes.
Could you possibly just send those in?
Of course.
Just for me to have a look at, really. But otherwise, thank you both again very much.
You're
Thank you.
welcome.
Thank you very much. Thank you.
We will resume at 2 o'clock with our next witness.
Well, shall we say 2:10?
Yes. I think we have another 2 witnesses together.
Yes. Okay. 2:10. Thank you very much.
Commissioner.
Good afternoon, everyone. We have Mr. Frett here, and I think we have Mr. Forbes remotely. Good afternoon, Mr. Forbes.
Good afternoon, sir.
You can hear and see us well.
Yes, sir, I can.
Good. And I think there was a slight problem with the bundle, but that's now been resolved.
We've found a workaround, and hopefully we can proceed with the hearing. Mr. Forbes had some technical difficulties, but
good. Okay. Now, Mr. Forbes, you're also due to appear next Tuesday at 10 o'clock and Thursday at 2 o'clock. Can you just confirm that you'll be attending then? Again, I think remotely.
Yes, sir.
Good. Thank you very much, Mr. Forbes. Mr. Rawat.
Thank you, Commissioner. Commissioner, in terms of representation, the Attorney General and the elected ministers are represented this afternoon, as they were this morning, by Ms. Martha Ikumeil, who is attending remotely. The remaining members of the House of Assembly who have participant status do not have a legal representative present at this hearing, remotely or in person. Our two witnesses this afternoon are Glenroy Forbes and Jeremiah Frett, both of whom have given evidence previously to the Commission and therefore do not need to make an affirmation or take an oath. If I could explain, gentlemen, that this morning and into the afternoon slightly, the Commissioner took evidence from the current and the former permanent secretary in the Deputy Governor's Office. And the focus of the hearing was on the arrangements that the BVI government enters into when it leases accommodation from private landlords. And so we've asked both of you to attend because you are either, in Mr. Frett's case, the current financial secretary, and Mr. Forbes' case, a former financial secretary, to see if you can assist the Commissioner further, particularly in relation to the role that the Ministry of Finance plays in the process. Now, Mr. Frett, you have the bundles. Mr. Forbes, I hope you have some documents that we will need to ask you to look at. Can I ask both of you, before we continue, just to remember to keep your voices up and to speak slowly. There may be occasions, and it happens, where we will speak across each other. If that happens, I will stop and I will let you finish your answer. Mr. Frett, before we continue, can I just deal with some formalities with you? Yes. You have provided, and it's one of a number of affidavits you've provided to the Commission over the course of time. This is your 6th affidavit, which you should have in a bundle in front of you. Can I take you to the 3rd page? It's short, it's only 2.5 pages long. Could you confirm that that carries the date of the 9th of September 2021 and your signature, please?
That is correct, Commissioner.
And you have exhibited to the affidavit a number of documents which relate to the topic under consideration at the moment, which is, for shorthand, lease arrangements. Can you confirm that you're content that the affidavit and its exhibits should form part of the evidence before the Commissioner?
Yes, Commissioner.
Could I just draw your attention to paragraph 1.3?
I'm sorry, Mr. Rawat, this is David. Can you have the witness come closer to the microphone?
Or perhaps draw your microphone closer to you, Mr. Frett. Yes, thank you.
Thank you. Just to paragraph 143, you make an observation which we've seen before, which is that you do not waive any privilege asserted in respect of a document where you mention it, unless you do so expressly. Are there any documents over which you do assert privilege?
None that I see here.
Thank you,
Commissioner.
Well, if I don't think it will, but if any issue does arise over confidentiality, there is a 3-minute delay, and so either you or your legal representative could raise the matter with the Commissioner. Can I just begin with you, Mr. Frett, if I may, and if I asked you just to turn to the larger lever arch file. If you turn up page 1, please. Now, this is a memorandum dated the 23rd of March 2021 from the Permanent Secretary to the Financial Secretary. And it's headed Commission of Inquiry Request. And it reads, or the Permanent Secretary, which is Mrs. Dabreo-Lettsome, refers to an email received from Mr. Jeremy Vanterpool, dated 18th March 2021, requesting answers, including documents, to 6 questions posed by the Commissioner of Inquiry. And what the Permanent Secretary then says is that the requested leases and relevant correspondence are saved on the enclosed external storage device. Now, in April of this year, a large amount of disclosure was made in response to a request to the Minister of Finance, which asked for leases between the BVI government and private landlords and other related documentation. There appears to be a requirement to lodge contracts or to send leases to the Financial Secretary as part of the process. And Mrs. Dabreo-Lettsome this morning explained that when leases are concluded, a copy will go to the Ministry of Finance. Against that background, could you just clarify, please, what you say at paragraph 1.5 of your affidavit, which is that you're unable to provide the information requested in the request, as the Ministry's role is limited to a presence on the Office Accommodation Committee and transmitting the relevant Cabinet papers and documents to the Cabinet for approval.
Commissioner, in response to the question posed, is that the subject matter lies within the Deputy Governor's office, and there may be information that I may not have that may be relevant to the questions that were posed. So I may not have certain documentations, notwithstanding that the Ministry of Finance sits on the committee. There may be other discussion, dialogue that we at the Ministry of Finance may not be privileged to.
But it's right, you don't disagree that the Ministry of Finance does receive copies of the leases that government enters into?
Mr. Chairman, from my knowledge, the Ministry of Finance should receive copies of all leases and contract, to my knowledge. But I cannot say exactly if they all were submitted and received at this time.
And you don't dispute that the Permanent Secretary and the Deputy Governor's Office sent to you a storage device containing leases and related correspondence in March 2021?
Mr. Chairman, as noted in the document, it was with my deputy, and I would not dispute that it probably was sent, but as far as I have physical, I've seen it, I cannot say that, but I don't doubt it was sent to my office. So I'm not disputing the issue.
Let's move on then. You explain, and this has been confirmed by the Permanent Secretaries who gave evidence this morning, that the Finance Ministry is a member of the Office Accommodation Committee, and that the Deputy Financial Secretary represents the Ministry on the committee. Given that and you go on to say that that the assignment to the committee is done verbally by the Financial Secretary, so that just means there's not a formal letter that you give, you just allocate your deputy to attend certain committees. In terms of reporting lines, though, how does it work between you and the Deputy Financial Secretary in this instance?
Commissioner, the deputy will bring to my attention certain matters that it may arise from the committee, but to my knowledge, there's not a formal line as far as minutes of the meetings, what took place, what decision was made. I don't recall having such information at my disposal.
the purpose of the committee, or one purpose of it, is to make recommendations to, in the first instance, to the Minister of Finance, and then ultimately to Cabinet, as to whether to authorise or a lease or not. And so, as a member of the committee, the Ministry of Finance will have a role in making recommendations. Do you leave that to your deputy to make those decisions, or are you involved in it at all?
Mr. Chairman, such matters are usually left to the person who's representing the ministry at these meetings. There may be a situation where the financial secretary may get involved, or they might be called into a meeting based on the magnitude of the situation to give an opinion, or there may be direct dialogue with the Deputy Governor's Office on particular matters.
I mean, we've seen an example of that because, we showed a memorandum this morning or a minute of the meeting to the permanent secretaries. And in fact, Mr. Forbes was recorded as a guest there. And it was explained that the reason he was recorded as a guest is because the financial secretary does not usually attend and is not automatically a member of the committee. But if you look at paragraph 2.4 of your affidavit, please, Mr. Frett. You say that the process is that the committee will submit recommendations to the Minister of Finance for approval, but through the Premier's office. And so the ministry doesn't have copies of those recommendations. It was explained why it goes to the Premier's office, even though the Ministry of Finance is involved. But it's right, isn't it, that when the ultimate cabinet paper is prepared, it will go through the Ministry of Finance to Cabinet?
Commissioner, that's correct.
And that paper will incorporate the recommendations that the Office Accommodation Committee is making to Cabinet?
That is correct. That is after, Mr. Commissioner, that will be after the Minister of Finance would have signed off on or approved the lease agreement. Yes. It will have to come back through the process. But just for clarity, Commissioner, just to clarify the statement made that I'm not aware, and perhaps this might be an area we can correct. The Minister of Finance and the Premier happen to be the same person. So therefore, sometimes, and it's not just in this particular instance, in other instances too, where they will send correspondences or certain matters for approval directly to the Premier's office, to his personal assistants, who would then give it to him. And the financial secretary may not be aware, being I'm like the permanent secretary for the Minister of Finance. So perhaps there should be where that the financial secretary perhaps should be copied on such correspondences that will let him be aware of what is taking place with such recommendations. But sometimes stuff goes through and you're not aware. Of course, the recommendation by representative on the committee would have knowledge of what the recommendation would be going forward to the Premier, but the approval and when it went and so forth, I would not have that information.
As on the evidence this morning, the process seems to be that the committee, which includes the Deputy Financial Secretary, makes a recommendation that goes to the Minister of Finance, but is sent to the Premier's office because that's where the Minister of Finance sits, doesn't sit in the Ministry of Finance. The Minister of Finance then makes a decision or expresses a view on the recommendation. It might then go back to the committee, which then prepares a draft cabinet paper, which then goes to the Ministry of Finance to finalise and put before Cabinet. Yes. That's your understanding, is that yes. Right? In terms of tell us if you can help at all in that, in terms of the Minister deciding whether to accept or reject a recommendation, is there any process or protocol around that, or is it just up to the Minister's decision?
Mr. Commissioner, sorry, I'm sure that the information or the document that goes to the minister will provide the argument for entering into the lease arrangement. So I think there's sufficient, I don't have the information, I don't know what it looks like to say right now, but I'm sure that the information is sufficient enough to where he can make the appropriate decision as far as to whether or not to enter into the lease arrangement.
If you look at paragraph 2.5 of your affidavit, you say there that the approval of, or the agreement of the financial secretary is sought where funding from the government is requested, and the financial secretary will advise on the availability of funding. The evidence of Mrs. Dabreo-Lettsome was that in some instances, a government ministry or department might fund a lease from its own budget, but in the majority of cases, the funding comes from the Deputy Governor's Office's budget. So what is the role for the Ministry of Finance in funding leases?
Mr. Chairman, Mr. Commissioner, I keep calling you Mr. Chairman, I don't know why. But Commissioner, with respect to the funding source, before a lease, even before they start to enter into negotiation with the potential lease, they have to make sure that there's funding available, or the process is well advanced for those funding. They may start the negotiation probably in this year, knowing that there's a commitment by government to enter into that lease for January. So there must be one funding in the appropriation bill, or there's some agreed between the government, whether through a cabinet paper or whatever, that they're going to enter into a future lease before that negotiation starts. They should not start the lease, start the negotiation of the lease without knowing what the source of funding is. So the Ministry of Finance plays a critical role. And it's not just for leases. No one should enter into the procurement of any goods or services without knowing what the source of funding is coming from.
The process, as we understand it from the evidence today, was that a government ministry and department can go and find alternative accommodation or additional accommodation, but they then need to approach the Deputy Governor's Office, and it then goes through the process of the committee. No one can sign a lease unless Cabinet authorises it. That's the understanding from the evidence this morning. Would you agree with that?
Commissioner, can you repeat that again? Let me get that clear.
The evidence is that whilst a government ministry or department can go into the market and find accommodation, what it then has to then do is approach the Deputy Governor's Office, and then the process starts. But no one can sign a lease or enter into a lease without Cabinet authorising it. And in fact, it's the Premier that signs the lease on behalf of the government.
Commissioner, from my knowledge, that is a fair assessment, but that is not written in law. That is a policy, and situation may dictate otherwise, where you deviate from that policy. I mean, we are in COVID, the situation right now where decision may have to be made that is in the law. It may not be part of the policy, but sometimes we may have to make decision based on the situation at hand, emergency or whatever way.
Well, I think,
but it's a fair statement what you made about
what the normal process
the normal process is.
Yes, and is that process written down, or is that just a practice that has been established?
Commissioner, from my knowledge, it is a practice or policy. I don't remember ever seeing it written down anywhere. It may be part of the Accommodation Committee policy, but I don't recall saying that, or if you are to enter into a lease with government, these are the steps that you must follow. It may exist, but I'm not saying I'm not aware of it.
But to go back to your point about, you said we are in COVID. The evidence from the two permanent secretaries this morning also covered what government had to do following the hurricanes in terms of sourcing alternative accommodation.
I think, yes, Commissioner, I think there was a cabinet paper with respect to how we enter into the discussion with Leases. I think there was a cabinet paper. I listened briefly, I was in and out of the conversation. I did hear part of that discussion this morning.
No, in terms of the role that the ministry plays and the financial secretary may play, when you're if you are being asked to provide additional funding, what factors would you take into account when considering that request?
Commissioner, if additional funding is required for a lease, of course you have to look at the nature of the request by the lease. So why are you requesting this additional money? It can be a situation of where the lease have not been renewed. There's a renewal clauses within the lease that the budget may not have covered, or someone might have missed that this renewal clause in the lease is due. And whether it's based on some formula, some CPI, some other requirement. So that might have been missed during the budget process. So therefore, when that comes now into effect, sufficient funding may not be there. So you may have to seek a supplementary or reallocate within the budget to cover that funding. There may be a situation where there may be upgrades to the facilities, and like my colleagues noted this morning, one of the biggest things is insurance coverage that skyrocketed after Irma. So some person tried to pass that cost on to the leasing, but so there's a number of situations that may cause the rental cost to go up.
Just generally, if you can help with this, Mr. Frett, please. I mean, I'm putting a slight hypothetical to you, but if you have a government department that has a budget and it will have different heads within its budget, if the department wishes to move funds from one head to another, for example, to fund a lease, can it do that of its own volition, or is that something that has to take back to the Ministry of Finance?
Commissioner, there's a process, there's a reallocation warrant in which they would apply through the application form. It comes to the Ministry of Finance. They will look at the different categories from which they seek to transfer monies from. And once we are satisfied with that, there's a place for the financial secretary, and it also goes to the minister to sign off on, to agree with the transfer of funds from whatever area to the office rent.
You've referred to a schedule of additional provision. Could you, which would be a ministerial department seeking additional funds above and beyond its allocated budget? How does that process work in reality?
Commissioner, I think we went through this in the last sitting, and it's basically a request is made, and it's made to the Ministry of Finance, and then there's a form, there's a process, there's an application form, and once that is submitted, the minister will review the documents. We see sometime in the supplementary, because of where the money is coming from, shifting from one particular vote to another, it may require that through policy, that matter be addressed through supplementary, not through a reallocation warrant, as it normally would. And the minister would agree or not to agree on the supplementary request that was made to shift the monies from one particular place, or to put new monies from whether from savings or new source
from elsewhere in government.
Yes.
Can it come from elsewhere in government?
Yes.
And is it a decision of the Minister of Finance rather than Cabinet, or is it ultimately a decision of the Cabinet?
Commissioner, eventually the matter goes to Cabinet, and from Cabinet then it goes to the House of Assembly for the final process.
So I think technically the minister approves it.
Yes.
Cabinet then approves it, and then
Because what happened that there may be supplementaries throughout the course of the year or within the last one.
and they're then gathered together.
Yes, then it goes to cabinet, then to the House of Assembly.
Thank you. One of the points is just to help me with this is if you go to your 2.9, you say that the final lease agreement, once signed by the landlord, is submitted to the relevant minister for signing. The evidence of Mrs. Stoutt-Igwe and Ms. Dabreo-Lettsome today was that it's always the Premier that signs. I mean, you seem to suggest that it could go to a range of ministers.
Commissioner, as it stands right now, all leases, as far as I know, they are signed by the Premier, Minister of Finance. The minister at any time can delegate that authority to his ministers. In the past, it was delegated. Such matters, the Premier may give authorization to ministers.
So that's similar to contracts.
Yes, for contract, the same thing. And then he would delegate that. But right now, as it stands, the minister signs all documents.
The Premier.
The Premier, sorry.
Could I ask you just to turn up page 372 in your bundle, please? It's an exhibit to your affidavit. The index to your affidavit describes this as memo from FS to FS to PSDGO, but it seems to be just a table that has various rents charged by different private landlords. Can you just explain how that, or if you can, how that note was put together, or what the document is?
Commissioner, in my office, I have a team. This is 367 on the number.
Yes, you're 367 and R372.
Okay, yes. Commissioner, the document here, I'm trying to familiarize myself with the document. But Commissioner, I do have a team in the office that compile these documents for me. And you can see the volume of the information presented. And this particular document here, I'm not 100% familiar with it. So I'm unable to speak intelligently on what it represents. But from looking at the Commissioner, it seems to have captured the rent and the security deposit for a number of properties that were rented by the government of the Virgin Islands.
I mean, the reason I asked is that it's, you say you have a team together, but it's, I think if I've understood your own index correctly, it is, it's part of it's a memo. It's described as a memorandum from yourself to, or from the Financial Secretary, Permanent Secretary of the Deputy Governor's Office, but it's not very clear on it. And the reason I asked about it, and I appreciate that you may need to take this away, but when we've undertaken the exercise of trying to compare the figures here against the documents that have been disclosed, we can't, there are two things arise. In relation to some of the landlords, we cannot see any record of sums actually being paid on the other documents. And the second is that one of them, if you see, Lake Development Company Limited. In 2021, it's recorded as charging just over 129,000 in rent. But actually, when you look at the documents that have been disclosed, it's a higher figure. Is this document something that's prepared? Do you think it's been prepared for the purposes of day-to-day business of the Ministry of Finance, or was it prepared for the Commission?
Commissioner, this document appeared to be prepared for this exercise. So, because it's not something that I have authorized to keep at our database, so I'm not familiar with this particular document and the format. So it had to be that it was prepared in trying to summarize or capture some data to present.
For the purposes of your response to the Commissioner. Yes. I see. Well, would you mind, I won't ask any further questions about it. Would you mind taking it away with you, Mr. Frett, and just, it's particularly just verifying the figures in that, because it's obviously a useful table if it's accurate, but I think we can't take it much further than that. Now, the purpose of, as I've said, is really trying to look at the process and the role of the Ministry of Finance, given we've heard from the Deputy Governor's office this morning. I'm going to just turn to Mr. Forbes and ask him just to turn up page 326. And this was the 2 pages that have been sent to you by email, Mr. Forbes.
Okay.
And to assist you, Mr. Frett, we're in the leases bundle. So it's not a page exhibited by yourself, it's in a separate bundle. If you turn up page 326, please. You have the document, Mr. Forbes?
Yes, I do, sir.
If I explain what it is, and it may be useful to have Mr. Frett's input on this, but it's a memorandum from yourself when you were Financial Secretary to the Permanent Secretary, or the Acting Permanent Secretary in the Deputy Governor's Office, and it's dated the 8th of January 2020. It relates to a particular tenancy agreement, but that's not the purpose of my question. What you say is that you write this: you may not be aware that persons like me have in the past worked tirelessly to extricate government from the abuse and wanton waste of public money occasioned by that abysmal time when central government was acting as landlord in tenancy agreement, the kind of which is now in question. The tried and proven solution was an Executive Council, now Cabinet, approved policy mandating that in instances where housing accommodation was part of the employment contract, the officer would be given an allowance. I would respectfully advise that we return to the allowance system for all such cases, except for the few traditional officers that were exempted, such as the judges and that of the Attorney General. With the effluxion of time, it's advisable that we seek to augment the level of the allowances to ensure that they are relevant given the movement of prices in the economy. Taking the general point, Mr. Frett, what was the issue that you were trying to flag up there?
Commissioner, at one point, government was involved in what I termed as being landlords. That there are a number of contract officers, primarily those who are expatriate officers, who, as part of their contract, they were given housing, what we call housing. But what I noticed back then was that that process was being abused by the recipients of those housing privileges, in that they would basically discuss among themselves and decide, some families just having 2 persons to the family, and they will want to have 2, 3 bedroom houses and stuff. And since government was paying direct to the landlord, that was a system that was ripe for abuse. And I must say back then, I was one of the chief proponents of another system where the post officer was given an allowance in those cases. And what I thought I saw from the correspondence that the PS sent to me was that a reverting to that same thing where government was getting in the landlord business, which I basically advise against strongly. I think I am normally a very soft-spoken person, but I can be very terse in writing. Sometimes I wonder why I had that beat my bonnet, when I read it over. But the point was that I was trying to divert them from getting back into the landlord business.
Thank you, Mr. Forbes. Perhaps we haven't sent you this, but if I could, or as a separate document, but if I could just draw your attention and canvass your view about what may be have been another bee in your bonnet. But this morning we canvassed with Mrs. Stoutt-Igwe and Mrs. Dabreo-Lettsome the minutes of an office accommodation committee meeting in October 2019, which you had attended as a guest, and you advised that the office accommodation committee needed to come up with a policy to determine what level of property the government should be renting, and that health and safety policy procedure in the workplace should inform that policy. And you also recommended that there must be some basic requirements met, and if they're not included, government shouldn't be renting the property. Essentially, you made the point that if you're just renting a shell, the government should be expecting to pay less than if the building came with certain amenities. Again, but can you help? This is 2019. Just in terms of formulating a policy as to the kind of buildings that government should be renting and what it should get for its money. What was your view when you were financial secretary?
Commissioner, what you expressed a while ago is exactly what my views were. And the thing that was driving that particular thing at the time was that I was trying to get government to agree or get cabinet to agree an average dollars per square foot, because we had great variation between what some landlords were quoting or asking for. And when you think about the properties that they were actually offering, they were at the lower end in terms of the level of accommodation. So I was trying to get persons to focus their minds, or the officers who were responsible for that, to focus their minds on making sure that they know what they're paying for. And if it's going to be on the higher, once you decide what level government was willing to pay in the market, you will decide which properties would be closer to the higher level and which properties would gravitate to the lower level. And it will be based on the amenities or the quality of the amenities that were being offered. So.
And so far as you are aware, during your time as financial secretary, was such a policy put in place?
I'm not aware, no, at least not in the detailed format that I was thinking or trying to nudge them towards.
Mr. Frett, what's your understanding of the current policy by which government operates when leasing buildings, in terms of having basic requirements or a certain rate per square foot?
Mr. Chairman, I try to recollect But I think that there was, I'm not sure it was verbally or by a policy where they said, but there was the ceiling, there was a ceiling on which they was trying to use for rental of properties, especially in the greater Rotan area. And also the enmities that went along with such rental of spaces, whether or not it would have had an elevator, access points in case of emergency. There's a number of things, but I think those things, I don't know if it was written in a policy, but it might be part of the Office Accommodation Committee and how they go about in assessing whether or not a property is viable for rental. I know that when we was looking to rent the spaces at a location, we had the chief fire officer and a number of other persons who went and actually visit the site and assess whether or not the site was deemed viable for rental. And they identify a number of things that the landlord, the potential landlord, needed to remedy before you could have actually rented the space. But I'm sure that the officer communities have their standards, their policy on how they go about it. I don't have sight of it to know exactly what it is. But from the Ministry of Finance perspective, I don't know if I can put my hands in. I don't know if it was a cabinet paper or what, but I know there was we're trying to introduce a threshold for rental for particular properties, especially in the greater Rotan area.
Above which government would not go?
Yes.
Do you know when that was introduced?
Commissioner, no.
And
I don't remember the year.
Did the ministry, I'm sorry, well, your voice dropped. So
no, sorry, I don't remember the year. No.
But how long, can you say how long it's been in place as a policy to have a ceiling?
I'll have to do some research on that. I'm sure my colleagues who are here this morning can assist me.
They certainly refer to a ceiling, but not, I don't think, a date.
No.
Yeah.
In terms of setting that ceiling, though, does the Ministry of Finance have a role to play at all?
Commissioner, just going by memory alone, and I think that the Ministry of Finance did play a role in setting that ceiling. I think there were discussions surrounding that. I would have been in a different position, of course, at that time, but my memory serves me correctly, there were discussions surrounding how much realistic should be charged for leases.
Commissioner, if I may butt in for a moment, sir. I believe that there should have been a recommendation coming out of the Accommodation Committee, well, to the Ministry of Finance, or to the Financial Secretary, who would in turn, using that advice the Minister of Finance so that he can take a cabinet decision as to what that ceiling should be. Because the Accommodation Committee, to which the Ministry of Finance has a seat on that committee, should be the body or the agency that actually make those type of recommendations, because they're the ones who are on the ground and seeing what is happening, what kind of requests are coming to them, what is the nature of the market that they're dealing with.
Yes, Mr. Forbes, I mean, that makes sense. And as I understand it from the evidence this morning, that if a recommendation came from the committee, then it would be signed by all of the committee, including the representative from the Ministry of Finance.
Sure.
Yes, Mr. Howard.
Thank you, Commissioner. If I could just move on, and it's returning to Mr. Forbes, but just try and understand how, and Mr. Frett, if you can help, because obviously you may have been involved when the Ministry of Finance itself has to go and seek accommodation, but just to use an example to just understand how the process works. Mr. Forbes, you should have a folder electronically headed Hearing Bundle Forge International.
Yes, sir.
If you could turn to page 9 in that bundle, please. what we're looking at page 9, if you have it, Mr. Forbes, is an email from yourself on the 15th of January 2020. And you highlight that there are problems with the air quality in the central administration complex. That space which is sought elsewhere for the Ministry of Finance is still not yet ready. And so what you decided to do, because of complaints from your staff about the conditions and the impact on sick leave, was to source accommodation, which you describe as occupier ready. Now, you're writing there and asking the Attorney General to vet the attached lease so that you can, as you say, provide transitional accommodation for 3 months in the first instance. Now, was that, do you remember whether that was a step that you took as Financial Secretary, sourcing and essentially signing up or getting a lease with a landlord without the need to go through the Deputy Governor's office?
So I must candidly state, right, that after witnessing what my staff at the Ministry of Finance and myself went through following the devastation of Hurricane Irma, in my desperation, I just sought some sort of accommodation for them, and accommodation there was limited. Honestly, I thought that it would be for a much shorter period. I thought it would be transitional, but again, like most things in government, it took quite a while. It's still ongoing, as a matter of fact. I think I heard someone mention to me on my way to my office some day ago that the Ministry of Finance is now moving to new accommodation, or they've started the process. And that's several months after I had entered into the lease with Forbes. You know.
So the circumstances led you to directly enter into a lease yourself?
I must say yes. There was no intention to snub or to belittle the role that the Office of Accommodation Committee plays, but I think at the time, since Mr. Frett, President, was the ministry representative on the Office of Accommodation Committee, he was aware of what was happening, and he could have communicated that information to the Office of Accommodation Committee. There was no plan to avoid anything. I just needed to do something for my staff to, you know, in dire circumstances, because the truth of the matter is, sir, following the devastation of the hurricane, I, as an individual, was busy trying to help everyone else. And those persons closest to me were the one that suffered most, because I didn't pay as much attention to them as I should have paid. I made a public apology for it some time ago. You know, it was awful.
So is it right that, I mean, we heard this morning about the work that is being undertaken on the central administration complex, and the Commissioner has seen evidence about the steps that were taken ultimately to move. It's approximately 300 officers, public officers, had to move out of that building. For how long was after the hurricanes, was the Ministry of Finance, or did you have your staff or some of your staff in that building?
The way, I'm not good at dates and stuff, right? But I know immediately following the impact of the hurricane, we had moved to 2 rooms. I had moved my entire administrative staff to 2 rooms at the at the FIA offices, 2 rooms. It's very cramped. Shortly after that, because of their need, that is the FIA need for its space, I moved my office back into the central administration complex without windows. There were some temporary wooden shutters put up, and it was in the cooler months. I remember it was in the cooler months. So it must have been in like March, February, March of 2018, where it was bearable because of the prevailing trade winds and stuff passing through the windows. But that came with the dust. If you ever been in that area of Wicomski 1, you realize that a slight breeze blows all the dirt, the stubborn dirt, and it comes into the building. On any given morning, you walk into that office, you can, as the older folks would say, you could almost plant potatoes in the soil, the amount of soil that collects on top of the desk. Okay, when it got much hotter, with the cooperation of the facilities officers, maintenance officers, they try to crank up or start up the air handlers, the air conditioning, which incidentally, there was a brand new air conditioner that was bought for an office, which was supposed to be the cabinet's office in the central administration complex. But and the hurricane did some damage to it, but not totally destroyed it. And that was the system that they tried to start up. And I can recall quite vividly how the problem that they had with it, because it was either too cold, and when it got that cold, there was condensation, so the floors were wet. There were persons who used to slip and slide on the wet surfaces, and all that the Ministry of Finance is going through, while at the same time, I am forcing them to focus and to help us get out of the crisis and get into full recovery. It wasn't a nice time, and I am prepared to take whatever blame can be laid at my feet with respect to what I did in terms of getting some space for them. There's no regret from me in doing what I did in terms of getting some space for part of my staff. Because I took my administrative staff and took up into another one of our offices, which is the project office. Took them up into the project office, and I had my whole administrative staff again up there in that space, a space that they provide us with. I think they're still there, if I'm correct.
Mr. Forbes, I just clarify. I mean, what the purpose of this question was just to understand how the process works from a ministry needing to secure alternative accommodation. So I think you've explained to the Commissioner that yours was an unusual situation, because yes, it's a situation where, it's an example of a government department entering into a lease directly without using the services of the Deputy Governor's office. Is that right?
Yes, sir. I think, they were not directly involved in the process.
So if we look at page 1 in the same bundle, we'll see it's another memorandum. It's from you to the Acting Accountant General. And it just confirms that you had entered into, you say that the lease agreement has been drafted, is now in the stage of being vetted by the Attorney General, and you then request of the Accountant General assistance in processing payment. So did you perceive the situation to be such that you had to move quickly?
Yes, the short answer is yes. My office had actually moved into the space before I made payments to the landlord. And I was going through the process of having the drafted lease vetted by the AG's chambers. The landlord was clamoring for his payment, rightfully so, and I was trying to get the assistance of the Accountant General to advance payment.
And so this was a situation where it was down to you. You identified the alternative property, you negotiated the lease, you agreed the rent, and then you took it forward.
Well, yes. To a certain extent, because at the end of it, there was a cabinet paper prepared, and it was advanced to cabinet. Yeah. Because I don't think, if I recall, I might be wrong on this, but I don't recall actually signing that particular lease. I don't think I was the one who signed it.
I mean, if you look at page 31, you'll see there that there's an invoice from the landlord, who is Forge International, and it's dated March the 1st, 2020. And it's so that invoice is coming to the Ministry of Finance. So that's when you'd started paying. So and if you continued, we can see in the papers, you then continued submitting invoices even before the lease had been finalized. Now, just in passing, the invoices themselves refer to rental of 16 desks. Could you just clarify what that actually meant? I mean, were you physically renting desks, or were you renting space? Or is there no difference?
It was explained to me by the landlord from whom we were renting, that the way he calculated the rental space was per desk. And that is what was explained to me and explained to the Attorney General's chambers at the time. So we were renting desks, actually. That's how it was calculated.
But Mr. Forbes, the office space went with the desks, and later on, say page 41 in the bundle, the invoices don't refer to desks from then on. They refer to rental space. So it was in fact space plus desks.
Commissioner, can I assist here?
Certainly, Mr. Frett.
With respect to the property at the paper, it is a space, it came with the desk. Exactly. It also came with a conference room. There was a conference room and a kitchen area that was shared as well. It's just a booking system for the conference room, and the kitchen was available to everyone to use, along with whether it be the microwave and other things that goes within that.
So however the landlord charged it out, it was for the space.
It's for the space.
Yes. Okay, thank you very much.
If we page 44 in that bundle shows that the lease was actually eventually signed on the 28th of September 2020. And it was signed by yourself, Mr. Forbes, the director of Forge International, Mead Malone, signing on behalf of the company. So it took. The effect was you got your staff in quickly, and then made payment, and then allowed the whole lease vetting process and finalization to just catch up.
At the same time, when I got the draft lease, I bumped it onto the chambers, and I had discussion about the lease as to when it was completed, you know, that is. But I think the point is I'm not in any way refuting that I did not follow the established policy, because the policy that I have weighed in on you know on several occasions, but I'm saying at that particular point and the level of well, there was some emotion in it. It was quite emotive, and I took action, because the least I could have done for my staff is to at least make some of them comfortable. Not all, some of them.
I think, to be fair to you, Mr. Frett, you explained at the time the conditions that Ministry of Finance staff were confronted with in the central administration building, to explain why you took the steps that you did. But could I turn to Mr. Frett, and Mr. Frett, if you turn to page 53 in the same bundle, please.
Commissioner, just for clarity, I know both of our names begin with F, so I think you're mixing us up interchangeably. You call him Mr. Forbes, Mr. Frett. So
not this time. I've got the right Mr. Frett, because it's perhaps been a long week.
Yes, I can imagine. And also, Commissioner, just for the record, also that Mr. Forbes been out of bit since he left the ministry. So he mentioned that I was on the accommodation committee. Actually, there was another one of my colleagues.
Was it Mr. Kettle?
Mr. Kettle was the one who was on the committee. So sometimes we forget. There's a lot of things going on.
Luckily, his name doesn't begin with an F either, no. So I'll be in trouble. If you turn up to page 53, though, it's just to finish off this little bit. So Mr. Forbes has explained the circumstances in which he entered into the lease. But what we see is at 53, there's the agreement is continued, and you sign that. If you look at page 58, Mr. Frett, because you're then acting financial secretary. Now, first question is, would it be right to say that the reason that you had to stay on in that property was because of the time it was taking to sort out the central administration building?
Commissioner, no. The reason that I signed it, Commissioner, is because the wheel of government sometimes don't turn as fast as even us as public officers would have liked. And we were hoping to move into the new premises much sooner. But by the time you go through the procurement process, we have the issue with COVID-19 that put us back as well, because with the furniture, we were supposed to move a long time ago. And just recently we got notice from the supplier that the furniture was delayed another 3 months. And therefore, we said we are going to move in to the current premises. Some of the staff move in to the Rita Frett George's building with temporary furniture, because we said we will end the lease arrangement. Because what you found is that every time it comes up, we say, let us extend. And the procurement process, the renovations, and we are even moving in without the elevator as well, to get out of the cost that was continuously happening in the temporary. What was initially was supposed to be a temporary arrangement turned out to be much longer. So we have finance recognized that we cannot continue that no longer. So we had made those adjustments to just move in, because the substantive work is done. It's just the final touches. It's taking furniture and the elevator and so forth.
And will that become your permanent home as the Ministry of Finance?
Commissioner, I'm not sure what the decision is of the Office Accommodation Committee with the Central Administration Complex. This is the first time that the Ministry of Finance, Central Finance, would be housed in one central location. In the past, we were about 3 or 4 different locations spread out all over during the hurricanes and COVID. And logistically, it is a nightmare when you have all these satellite office. So I will be discussing the matter with the Office Accommodation Committee and the Minister to voice my concerns that if having satellite offices, several satellite offices is not beneficial to the Ministry of Finance and the organization as a whole. So I would prefer to have a central place where the whole team is housed together.
Now, in relation to this page 53, the contract that Mr. Forbes entered into was for a year, and we see there that as of the 27th of February 2021, that there's essentially another agreement. Now, how were you able to sign this lease as financial secretary, given that our understanding from the permanent secretaries is that the Premier would sign off on leases?
Commissioner, like my predecessor said, this lease was already, the arrangement was an ongoing arrangement, and the situation we was hoping was just a temporary one. And once the lease came to a conclusion, the previous one, in hindsight, Commissioner, that should have gone to the Premier, should have gone through the process. So it basically what you saw is a continuation of the current arrangement we had with the leasee, where the Ministry of Finance was administering it.
So in the normal course of events, is it can a department or a ministry just itself renew a lease, or should that really go through the Deputy Governor's Office and through to Cabinet?
Commissioner, that is the ideal process as far as I know it. In this situation, as I indicated, that it is not a normal situation that we had within the Ministry of Finance. And in hindsight, the Office Accommodation Committee perhaps should have been involved, even if it's not in the initial one, perhaps in the renewal process. So I just followed suit of what was done previously, but in hindsight, maybe that should have been the better option and have the Premier sign off on the leases. The key is that we was hoping every month, we hoping we'll be able to, every period, we hoping that we will move. And the situation that causes say, okay, you can't move. And it always seemed to come like the crunch time, and a decision had to be made to advance. So it never was intended for any long-term lease, it was short-term. And from the Office Accommodation Committee, normally deals with longer-term leases and not so much temporary type arrangement. As far as I know,
permanent secretaries this morning explained the challenges that public officers face in the immediate aftermath of the hurricanes, and the steps that people had to take to get services back up again. And you may not know this, Mr. Frett, but obviously you're a long-standing public officer, and you've been a senior public officer for some time. But, is it within your knowledge that in the immediate aftermath of the hurricanes that departments had to take measures of the sort that Mr. Forbes had to take to try and secure safe accommodation for their staff?
Commissioner, in my view, the health and safety of the staff is paramount. And I don't know if you saw the videos or the pictures of the aftermath of Hurricane Irma and the destruction that it caused, not just to the central administration, Ralph O'Neill administration complex, but also to other premises. Mr. Forbes already laid out where we sat. We are actually sitting on top of each other up at, actually the right below Rosham premises with FIA, or the person with dispatch. We had some person working in basically from home. And that was difficult in itself because of the telecom system not being operative. So the conditions at the time may have warranted some persons to take drastic decision in the health and safety of the team. What we have learned a lot of lesson, Commissioner, from the hurricanes and even from COVID as well. It has taught us that we need to probably have mitigation measures in place in the event of a major hurricane, how do we deal with staffing matters, housing of staffing matters? We think about feeding and all these different things, make shelter, but how do you keep government operation going? And I think we have learned a lot of lessons from that. And even in COVID, to Commissioner, we continue to learn actually, because the situation is still evolving within COVID. It's quite fluid, and we are learning how to deal with spacing distances. We will love to have cubicles more closer and maximize the spaces. Now we have to start thinking, okay, how much person should we be allowed on this particular floor? And in our new premises that we're in, it allows for social distancing and all these other things to keep the staff in a safe environment. I do believe, Commissioner, that not just because of the Commission inquiry, but even well before that, the DDM, DG office, and a number of DG and other processes have recognized that we have to, how do we cope in catastrophic events such as COVID? And they have done that. In my view, we continue to do a good job as situation presents itself. Perhaps there need to be a more comprehensive approach in dealing with such matters so that everyone would know what are the policies and this is how you should go about it. I know that Ms. Dabreo laid out a process in how we should deal with it. Now that needs to be communicated through our government, this to all accounting officers. And this is the process you cannot deviate in. In what situation do you deviate from that process? I think that all that would be helpful going forward. I don't think that no one in those situations would have done so willingly trying to circumvent a system. They did it for the health and safety of their staff.
But moving forward in time I was going to say to better times, but of course, as you've pointed out, we're now sort of coming out of a pandemic. But in terms of the knowledge within your ministry about the process by which, or the lease arrangement process, is it your view that there needs to be better information disseminated about what that process actually is and the role of the Deputy Governor's Office and etc.?
Commissioner, I do believe as a result of you asking a number of questions into the Commissioner inquiry, I think that dialogue already started. And I think that there's some positive coming out of the dialogue, and knowing Ms. Dabreo, she's very keen on such matters. I know that we will sit down, and notwithstanding that the Ministry of Finance sits on the committee, it needs to be disseminated much wider on how we address such matters. I know that the new team that they have assembled in the Deputy Governor's Office, they are reaching out to us. Mr. Payne and others have been reaching out to the ministry with other accommodation matters and trying to make sure that we follow certain procedures. I know one where we thought everything was clear and free to go, but come now to find out that I would not have thought about that's part of their process to check with land registry to make sure the ownership and there's no lien and all these issues like that. And when they went and checked, there's issues. So we had to put a halt, but a lot of things already started. So these are some of the things that through the leadership of DG and through collaboration. So these things, I'm not sure how. I know that Ms. Dabreo is probably listening, but I'm sure that the process, if we start a negotiation discussion outside of the accommodation committee, which can happen, you can just go out and say and carry the recommendation into the office accommodation committee. I identify this place for this particular reason. I would like the accommodation committee to look at it. But in doing so, even before you reach that stage, they're now telling us that you need to do some legwork. You need to go to land registry. You need to check ABC. You need to find out the true owners and all these things. So I think that a proper policy laying out these things will help in the process going forward. Commissioner.
Thank you very much, Mr. Frett.
One last question to you, Mr. Frett, as the Financial Secretary. The evidence of Mrs. Dabreo-Lettsome this morning was that government wants to reduce the number of leases that it has, so that the balance is in favour of officers occupying government-owned property. Speaking as Financial Secretary, can you see any benefits in that approach?
Commissioner, I advise, and the policymakers would make that decision. But if I was a policymaker, I know that I would build a number of government administrative complex to reduce the cost of rental income. That's just my personal view. I'm not the final decision maker, so I don't want my minister.
That's your view as the Financial Secretary, and it's an understandable one. Yeah.
Yes, we can reduce significantly the rental cost, and as the service grows, and it's very costly. And I also think that we often say that the leaser can do much better in their pricing, but they have to also take into consideration the mortgage payment, insurance, and other matters. But I still think that the cost of rental is very high, and it would be beneficial for the government when you calculate the overall rental income. If we could have somehow, under the current FSP, the same way to have at least one or two more administrative complexes to ease that burden of external rental costs. That's just my personal view. So.
Thank you. Commissioner, I've reached the end of my questions. Can I conclude by thanking both Mr. Forbes and Mr. Frett for attending and giving their time to the Commission, and also for the way in which they have given their evidence this afternoon. Thank you.
Yes, and can I echo that, Mr. Forbes and Mr. Frett? Thank you for your time, which is valuable, but also thank you for the thoughtful and helpful way you've given your evidence. It has been very helpful.
Commissioner, can I beg your indulgence to make one comment, please, sir?
Go ahead, Mr. Forbes.
Yes, and I'm following on something that Mr. Frett said earlier. I believe the whole question of office accommodation for the public service should benefit from a policy. You have a general policy that lays down some parameters as to what type of property we should be looking at, what standard we should aspire to, and the costs in the market that you should be looking at, cost per square foot or what have you. Because I'm convinced that just by saying the Minister of Finance or the Premier should sign a release, that does not lead to efficiency or effectiveness. So what's going to lead to effectiveness or efficacy of the whole thing is that we have a policy that has certain parameters, and the public servants are allowed to make decisions within those parameters. Parameters, I want to repeat again, parameters that have been endorsed by Cabinet. Thank you very much, Commissioner.
Thank you very much, Mr. Forbes. I mean, from my understanding of the evidence this morning, that the Permanent Secretary does have standards for various different sorts of accommodation, which are really set out in checklists. And there is at least a cap on the rentals to be paid. No doubt that can be finessed, but there is some form of system in place. But thank you for that comment, Mr. Forbes.
Commissioner, you said Thursday we have to return? No, the reason is I'm on vacation, so.
Mr. Forbes, I think Tuesday and next Thursday, and Mr. Frett is. We'll check Mr. Frett. We'll check Mr. Frett.
We'll check and update you before you leave the hearing room, Mr. Frett. But if I could ask you, Commissioner, just to rise briefly so we can set up for the next witness.
Yes, thank you very much. Thank you, Mr. Frett.
Thank you, sir.
Good afternoon, Mr. Lendor. Can you see and hear us?
Good afternoon. Yes, I can.
Good. Thank you very much, Mr. Rawat.
Thank you, Commissioner. Our final witness of today is Mr. Lenius Lendor. Mr. Lendor, I understand that you wish to take the oath. Do you have a copy of the Holy Book with you?
Yes, I do.
If you could take it in your hand and read these words after me. I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth, the whole truth.
Shall be the truth, the whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you very much, Mr. Lendor.
Thank you for making yourself available. Because you're outside the BVI, you're attending remotely. But can we start off just with some formalities, please? Could you give the Commissioner your full name?
My full name is Lenius Julius Lendor.
And I understand that you were formerly Managing Director of the BVI Ports Authority.
Yes, that's right.
And were the dates of your that you were in that role from August 2018 to January 2020?
Yes.
Could you, Mr. Lendor, just give the Commissioner a brief outline of your career before you were appointed Managing Director?
Yes, well, okay, I started off as a teacher at St. Mary's College, my alma mater, secondary school for boys. I spent 4 years there, but whilst these 4 years were going along, I did a Bachelor of Science degree in Social Sciences at the University of the West Indies in Trinidad. I then left teaching to become the administrative assistant to the Director of Research and Development of the Windward Islands Banana Growers Association, following which I started my career in the ports industry as the Chief Administrative Officer of the St. Lucia Air and Seaports Authority, where I was the head of the business, the HR department, company secretary to the council, and leader of the authority's negotiations team. During that time, I did an MBA at the Cavell School of Business. And when I finished that master's degree in business administration, I also did a diploma in international senior port management at Galilee College in Israel. And I also did further training in port operations and management in Singapore. I was then appointed as the manager of St. Lucia Marine Terminals Limited, which is a wholly owned subsidiary of the St. Lucia Air and Seaports Authority, to manage the Vieux-Fort Seaport as the primary transshipment port in the OACS. I took up that post in 2000 until 2015. During these 15 years, for 8 of these 15 years, I served as the vice chairman of the Port Management Association of the Caribbean for 4 consecutive 2-year terms, and for 4 years as chairman of said association. I was made an honorary member in June 2019. Thereafter, I took up the post as Chief Executive Officer of the National Insurance Property Development and Management Company. And I resigned that post to take up the post of Managing Director of the British Virgin Islands Ports Authority.
Thank you. And in terms of being appointed Managing Director of the BVI Ports Authority, did that follow after an open competition?
Yes, the post was advertised. I applied, I was interviewed. Other persons, I'm not sure how many, were also interviewed, and I was selected, and thereafter followed a cabinet conclusion and an appointment by cabinet to serve in that capacity.
And you, as the managing director, you sit as an ex officio member of the board of the Ports Authority. Is that right?
Yes.
And in your time, that you were the managing director, just give the commissioner a brief outline of your role. What did you see your job to be?
Well, according to the legislation, it clearly states there are certain things that the managing director, the responsibility of the managing director under the Act, being responsible for the overall management, day-to-day management of the authority, and to work in conjunction with the board of directors in the interest of the organization.
Was it part of your remit to give advice to the board on port matters?
Yes, that would be part of it as an ex officio member of the board. When the board convenes, we could have deliberations, yes.
And did that include policy formulation?
Yes, the managing director could influence that, though ultimately the board, as an entity, as a unit, would be responsible for approving policy for the organization.
Now, the reason that we've asked for your assistance this afternoon is because the commissioner is investigating the way in which government bodies enter into leases with private landlords. And we've heard today from public officers within government itself, and you have been asked to assist because you were managing director of a statutory body. So my first question to you, and I take you just please to page 12 in the bundle that we've sent to you.
That's bundle number 1?
Yes, I hope so. It should be headed BVI Ports Authority Leases bundle.
Yes.
And if you go to page 12,
yes, page 12.
If I explain, Mr. Lendor, page 12 is part of an affidavit by Kelvin Hodge, who is the current chairman of the BVI Ports Authority. And in that capacity, he was asked to assist the commissioner with certain pieces of information. But he explains that he was appointed chairman of the board on the 13th of May 2020, but didn't take office until the 25th of June 2020. And the matters to which the affidavit related occurred before he took office as chairman. But at paragraph 12, if you look at paragraph 14 on page 12, Mr. Hodge was asked to address the relevant framework, law, policy and practice in relation to the BVI Ports Authority's procurement and management of leases. And his response was that based on the information available to me, I'm not aware of any formal framework. The focus was to identify potential spaces, identify their suitability based on the BVI Ports Authority's needs, and identify the lease rate. Nor am I aware of any unwritten or customary processes that the BVI Ports Authority follows when entering into a new lease. However, once suitable space is identified, the board will vote on the matter, and often a lawyer will review and advise on the lease before execution. Now, taking it back to your time as managing director, so far as you're aware, was there a policy in place by which the Ports Authority would seek accommodation to lease, or was it done on a case-by-case basis?
I am not aware of any written, any formal policy. As a matter of fact, the authority even hardly ever had to lease, as far as I know. Much of the leasing would have been occasioned by the damage done by the hurricanes, and then the need for new space and the need for the authority to lease property, for example, rental space for offices. So I'm not aware of any policy on leases.
You explained that the policy, like the Ports Authority, like many other bodies, had to respond to the impact of the hurricanes. So in your time, what process did you follow when needing to find additional space or property for the board?
Well, the only occasion that the only instance that arose was with respect to the need to get some accommodation to house some of the port staff who were in cramped conditions at Port Purcell. So that was the only occasion, and in the absence of any formal written policy, we would have not had any specific guidelines to follow. So the usual thing would have been to go out and source suitable accommodation and evaluate the merits of each location, the pros and cons, and make a decision based on the costs and other factors, the location, value for money, suitability for the purpose intended, and so on.
Were you yourself involved in that process of seeking out alternative space for staff?
Not actively, because again, being from St. Lucia, and only being less than a year in the BVI, I would have deferred to the local persons on the senior management team who know the location and the territory, the area much better than me, and who know people and potential places and could advise and so on.
If I could just ask you to turn up page 111, please. Let me know when you've got the page.
Yes, just scrolling down to page 101, right? Yeah.
111, please.
Oh, 111. Yeah, 111. Yeah. Okay. Yes, okay, 111.
This is part of minutes of a meeting of the Port Authority Board from the 25th of July 2019. Yeah. And you can see at item G, there's an item headed office space. And there's a reference to the board and some managers having looked at potential space in Palm Grove House, but it lacked parking and there is lots of work left to complete the space. And it then goes on to report that the board had agreed to rent the building a building on the highway owned by VOP Investment Limited, effective the 1st of August 2019. I'll come back to that, because I think that's the building that you're thinking of that the board did actually rent. But in terms of the reference to Palm Grove, on the papers that the Commission has received, there's no evidence of either the board or managers looking at other properties. Can you help at all if other properties other than the building on the highway and Palm Grove House were looked at?
No, I'm only aware of Palm Grove House being looked at because I was one of the persons who was there with some persons from some senior managers and some board members looking at Palm Grove House. And thereafter, we went to the other property on the highway.
Thank you. The next question, just to canvass with you, is if you look at page 113,
yes.
You'll see that this is now a minute from another meeting of the Ports Authority Board from the 31st of July 2019. And item 11 is a presentation by the General Counsel. So that's, I think, Natalie Sandiford Francis.
Yes.
And presumably the General Counsel was standing counsel to the Board Ports Authority, is that right?
Yes, the General Counsel would have been part of the management team. Yes, so she would have been one of the senior managers.
What on this item, the General Counsel is reporting on draft policies and also staffing for her office, but her focus is on documents prepared as recommended by the National Risk Assessment Council. Because what the General Counsel reports is that in 2016, the National Risk Assessment Council advised that the Ports Authority was to create various policies, including 1, a conflict of interest policy, 2, policies to deal with issues such as money laundering, bribery and corruption, and 3, political interference. And the minute note continues that as a result, the requisite policies were drafted. The General Counsel further reported that the drafting of the political interference policy is incomplete because time has not permitted her to do so. And she then dealt with other matters that were taking on her time. But the question that I wanted to raise with you, Mr. Lendor, was this. The General Counsel in July 2019 is saying that the policies are nearly complete, available in draft. During your time as Managing Director, did the Ports Authority Board implement a conflict of interest policy?
No. Just to put it in context, the General Counsel was fairly new. She was recruited soon after I arrived, when I made a recommendation to the then board that we needed an in-house General Counsel because of so many legal matters that we had to deal with. So we recruited her, and she was reporting to me as the MD. And we discussed some things to give priority to. And these were some of the policies which she drafted and submitted to the board.
And we've got 3 policies that the General Counsel produced or was producing: conflicts of interest, policies to deal with money laundering, bribery and corruption, and political interference. Were those policies aimed at both members of staff and the board?
Yes, they were. we were particular to ensure that conflict of interest could reside at various levels, and the policy aimed to cater for all of that. As a matter of fact, as management, we went as far as discussing the policy as management and how it applied to persons on the management team. And in submitting it to the board, the intention was for the same thing to happen, for the discussion, so the board would understand their part in the whole policy.
Taking conflict of interest as the example, what was the end point that was reached during your time as managing director?
Well, following the submission of these draft policies, the board actually did not really, even as far as I know, discuss it at any length, far less approve it. So it did not go further than just a draft.
And that's where it was. It's still in draft when you left your post as managing director.
Well, I didn't leave my post, but yeah, okay, yeah, up to that point, yes. In terms of well, you've said the policies were still in draft, but was there a process by which, for example, members of the board could declare an interest in an item on the agenda? Well, even without a policy, the general practice appeared to have been that if there is a conflict of interest and a member is aware, would draw that to the attention of the chairman and the rest of the body and excuse themselves from the room whilst deliberations on that particular matter where the conflict existed was being dealt with.
And they would physically leave the room? Physically
leave the room. I have seen that, yeah, on occasion.
What was that then recorded on the minutes that someone had declared an interest and they had then left the room?
Well, it should be, yes. It would be recorded, so and so left, and when the person returned, would also be recorded.
The next issue I'd like to canvass with you, please, is whether there was firstly, it's just budgeting for leases. Mr. Hodge, in his affidavit, noted that for the one lease, and we'll look at some of the detail in a moment, for the one lease that the BVIA Ports Authority did enter into, there was no rent budget in place prior to the board's decision. And he makes the point that the Ports Authority hadn't rented office space in recent times. So far as you are aware, in terms of a policy, was there any policy in relation to how the board would deal with, and the Ports Authority would deal with making sure they had the budget to enter into a lease?
Well, having already said that there was no formal policy, what would happen if the authority intended to enter into a lease during the financial year? Budgetary provision by the relevant department, maybe admin or whichever department it would fall under, finance would be aware that during the course of the year, there's an intention to lease property and make a budgetary provision for it.
If you give me one moment, please. If you could turn up then, if we just look at in a little more detail of the process by which the board did enter into a lease for one property. If you turn up page 116, please. if we're in the right place, it's a letter from Vernon Lake of VOP Investments Company Limited,
Yeah.
to the then chairman of the BVI Ports Authority Board, Mr. Nathaniel Isaac, and it's dated July 9th of 2019, and it's submitting a quote for the commercial space viewed by the board. Now, this is the space that the board or the Ports Authority ultimately took on, but it's commercial property at Passier's Place. But were you involved at all in arranging for a quote to be taken?
No, I was not aware of that.
We've seen already that on the 25th of July 2019, and we've seen the minute, but that the meeting universally or unanimously passed a motion to rent that building effective the 1st of August 2019. If you turn up page 114, please.
Yes.
That's returning to the minute of the 31st of July 2019, and under item 12, continuation of other business, lease of property, one of the members of the board, and that's Mr. Bevis Sylvester, reported that he'd visited the container port yesterday, did not like the condition of the offices, and his understanding was that office space was being sought and a number of properties viewed, and he then requested an update, and it was reported that the Port Authority had already decided to enter into a rental agreement with VOP Investment Limited. Mr. Sylvester then reported that the MD, that's yourself, had presented him with a list of required documents which had been raised by the General Counsel this morning, which included items such as a certificate of good standing. And he asked if the information was provided by those concerned, and he was informed this had not yet happened. And Mr. Sylvester then moved a motion which was seconded by the Deputy Chairman, who was at that time was Roxanne Sylvester, which it was that the Ports Authority should proceed with the lease of the premises from VOP Limited, pending immediate receipt of the amended contracts and the documents listed, that if the due diligence information were not provided by a date, this is the 22nd of August 2019, the contract will be voided. So what seems to have happened at this stage is that you had raised with the board, or certainly with Mr. Sylvester, the need to undertake due diligence. So just tell the Commissioner a little bit more about what process you identified as required.
Well, based on the memorandum from the General Counsel that we referred to earlier, and the contents of it, it was readily clear, it was most apparent that there were issues that needed to be addressed and dealt with prior to entering into the list. So basically, these were the matters that the issues, the advice that the General Counsel gave, just impressing on all concerned that has to be addressed before we enter into any lease arrangement.
And if we see at 123, please.
Page 123?
123, please. This is a letter from the General Counsel to VOP Investments Company Limited, setting out what's described as due diligence requisitions as part of the pre-contract process concerning the rental of premises known as Passier Place, and asking for a response. The next document that we can then look at is at 128.
Yes.
This is a memorandum from the General Counsel to you as Managing Director relating to the proposal to rent that building from VOP Investments. And she explains at the second paragraph that, or if we take it from the first, that she had received 2 copies of a lease from the chairman of the authority with verbal instructions to review those. And then she raised, having reviewed the lease, she raised a number of pre-contract inquiries, made several requisitions for documents. And these then, and this was in order to conduct due diligence in respect of the proposed arrangement. The memorandum explains that the pre-contract inquiries, due diligence requisitions were then handed to the chairman by the General Counsel on the afternoon 30th of July, along with proposed amendments. Following the board meeting that we've just looked at, General Counsel was prepared, as we've seen, it was instructed to prepare a cover letter to make pre-contract inquiries from VOP Investments. And then she was informed on the evening of the 1st of August that the board wished to proceed with the transaction as soon as possible. She adds, given the apparent urgency of the matter, she proceeded to the land registry on the morning of the 2nd of August to conduct a search of the land registry to confirm that the premises to be leased by the authority are owned by VOP Investments Company Limited, as represented on the proposed lease. But her inquiry showed that the property wasn't owned by VOP Investments Limited. And there's no lease registered which shows that VOP Investments is the registered lessor of the premises. And then she flags up on the next page that the Town and Country Department had raised a number of issues in relation to an application concerning the premises. And so what she raised, and this is at the bottom of 129, just taking it quickly, that she recommended the owner of the property be asked to present proof that directions from the Town and Country Planning Department have been complied with, because if not, the board may be at risk. At page 130, the General Counsel continues, in carrying out due diligence, I also visited the Corporate Affairs Registry on 8th August 2019. My search at the Corporate Affairs Registry revealed that the correct name of the proposed lessor is VOP Investments Limited, not VOP Investments Company Limited, as appears on the proposed lease, and that, she pointed out, would need correction. She then continued that Section 30 of the Registered Land Act, every person acquiring a lease is deemed to have notice of every entry in the land register relating to that land or lease. And as such, the authority would deem by law to have notice of the actual owner and cannot later claim it wasn't aware that the property was not owned by VOP Investments Company Limited or VOP Investments Limited. And she then says it's imperative that VOP Investments Limited be now requested to produce a copy of the lease between Patsy Lake as owner of the property, which is the property that the board was planning to lease, as owner, as lessor therein, and VOP Investment Limited as lessee therein. This is of utmost importance to show that the VOP Investments Limited is entitled to sublet the premises. Otherwise, the proposed lease should not be executed by the authority. The General Counsel then enclosed further due diligence requisitions for VOP Investments, and she recommended that to protect the interest and reputation of the Port Authority, that documentation be obtained in response to the following requisitions. And one was whether any feasibility or other research was undertaken to determine the amount of space required to house staff of the authority, were any other premises considered for rental of space. Thirdly, whether any member of the board is an interested party or connected person to this transaction. And fourthly, if any member of the senior management team of the Ports Authority is an interested party or connected person in this transaction. So I'm summarizing rather swiftly the content of the memorandum. but what we haven't been provided with is a response to that. Can you assist the Commissioner with, in terms of what further steps you were able to take as Managing Director, having received that memorandum?
Well, on receipt of that memorandum, it's very vivid in my mind because I received it late on a Friday afternoon, I think. And I immediately, well, I called her to just touch base and confirm everything that, you know, because I know she was doing that due diligence. And that's the memorandum that resulted from it. So I thought it prudent to immediately apprise the board of such significant matters. And I proceeded to forward that immediately to the board with a view to, of course, us they being aware and for us to discuss and if necessary to have the General Counsel expound on whatever matters and so on, which is what I did with immediate effect. So the matter was known to the board, and apparently not based on the action that followed, it didn't appear to be well received because I know an emergency, or the records will show whether it was called a special board meeting or an emergency board meeting, was convened the following working day, which was Monday after the weekend from Friday. And the board convened and the matter, and they passed a resolution to make the post of General Counsel redundant with immediate effect, and for it to take effect today, meaning that same Monday. And there was, and to outsource the function of legal counsel for the authority, to outsource it, and that redundancy with respect to GC to take immediate effect. And that's what the board did following receipt of the memo that I sent them for their information and to discuss.
So you provided the board with the full memorandum written to you by the General Counsel?
Yes.
And you'd received it, you say, on a Friday evening, but by the Monday, the board had resolved to dispense with the role of General Counsel?
Yes.
How long had there been, you explained earlier that it was on your recommendation that the board set up a General Counsel post. How long had General Counsel been in place?
The General Counsel would have been in place maybe for about 8 months or so, but it was under a different board because in the interim there was general elections, there was a change of government, new board. So that was not the same board that approved my recommendation to bring in a General Counsel. That was the new board. So these are new directors.
We've seen that the memorandum is dated the 8th of August, 2019. If you turn back to page 117, please.
Yes.
This is, I think, a copy of the lease. It's the copy that we have, but it gives the date from which the lease would run as the 1st of August 2019. So far as you're aware, Mr. Lendor, and I should say that it has annotations on it, so it appears to be a draft, and the annotations may be those made by the General Counsel. But so far as you're aware, did the lease start to run from the 1st of August 2019?
I am not 100% sure. I cannot recall exactly, but the records would show because payment would be made from a certain date. So I'm subject to, I'd have to double check that with finance, and I can recall for sure.
But in terms of the four matters where the General Counsel advised further due diligence that the board should take forward, although you say the board resolved to make that General Counsel role redundant, did they go on to consider any of these matters with you?
No.
So just so that was there any further discussion about the question of a feasibility study?
There is no further discussion on any aspect of the memorandum.
Thank you. What then followed in terms of the timeline, and I can take you to it if you need, but quotations were obtained from various contractors. So for example, there was a quotation obtained from Caribbean Security for the installation of a burglar alarm system, access control and video surveillance. A quotation was sought from Edward Sandy DBA, International Change in Construction. That then led to an agreement in October for the outfitting of the premises with sheetrock walls, doors, paints, and finishes. And that work was to be completed by the 1st of December 2019. And then on the 5th of November 2019, Caribbean Security did enter into an agreement to fit in security systems. And there was then in November 2019, work done in relation to wiring, in relation to fitting an air conditioning system, further electrical works. Before the board entered into the lease, were you and they aware of the amount of work that would be needed to fit out the premises that you were wanting to rent?
Well, the fact that the board and management, the same persons who visited Palm Grove, also visited that these premises, we would have seen everything, what was in existence, what was needed, what was not in existence. So the board, everybody who was on the visit would have been aware of what's required to make it fit for purpose.
Were you tasked to undertake any preparatory work to identify how much it would cost to make the building fit for purpose?
No.
Was there any discussion about how long it would take before the building would be fit for purpose?
No, just a general sense of trying to get these things done as expeditiously as possible.
Did you yourself, I mean, the proposed rent, and we've only seen this in the draft, is that the annual rent was going to be $295,000. Were you involved at all in negotiating that rent?
No.
Who, so far as you're aware, was involved in negotiating the lease?
I'm not aware of any. That's just a figure that came. I am not aware how that figure was arrived at, or anybody who was involved in negotiating it.
But I mean, the General Counsel's note speaks of being handed a lease by the chairman of the authority, or copies of the lease by chairman of the authority, but I mean, were you at all at any time asked to comment as managing director on the terms of the proposed lease?
No.
Are you aware, I mean, you attend meetings as an ex officio member. Were you aware of discussions about, by the board about what the lease terms should be?
No, any such matter would have been in the minutes, and as you could see from the transcript of the minutes, there's no such discussion.
I mean, would it be the role of the managing director to undertake the task of negotiating the detail of a lease?
Well, normally the managing director and his team, maybe you'd include the projects manager and somebody from finance and so on. Yeah.
And in terms of taking the project forward after the lease had been signed, did that fall to you to do as managing director?
What do you mean taking it forward?
Well, a lease is entered into. The building requires some fitting out to be fit for purpose. Did the board ask you as managing director to take that forward and obtain quotes from contractors for various things?
No, no. Pretty much everything continued in the same vein, where nothing was delegated or passed to the managing director to do. So there's nothing specific that the managing director had to do with respect to taking the matter forward, except that, of course, some contractors were identified. It was not an open tender, but maybe a selected tendering. Persons would have asked people they believe who could do the work based on their experience or maybe past works to submit quotations, and on the basis of that, one would have been selected.
If we take into stage, so in terms of the lease, do with the lease at all, is that right?
No, I wasn't involved in the lease or even anything pertaining to that particular property.
So who put the lease before the board, as far as you're aware?
I'm not aware of who put the lease before the board.
And in terms of selecting the contractors who would be involved in the fitting out, you didn't play a role in that at all as managing director?
Again, because of not being from the territory and not knowing, having a track record of working with contractors in that field and so on, I would not know even who has done similar work elsewhere and whether the work was good and whether to ask them to quote and so on.
But was it therefore other members of the senior management team who had that knowledge who were asked to go and do that?
Well, the board was very, very hands-on in all of that too. These things were not just delegated to management to do. The board was very much hands-on in these matters and involved in all these matters.
If you can be a bit more precise, if you just take it from the time that the decision was first made to enter into this lease, in what way were the board hands-on?
Well, from my experience dealing with the board, that particular board was very hands-on. Maybe some boards would restrict their role to policy matters and setting the parameters for management to operate, but that particular board was very much hands-on and very much involved in operational matters and so on. So that was the modus operandi.
And was that a way of working that you were used to?
No, I was not used to that. I've been reporting to boards for the past 20 years. That one was the most hands-on of all. In fact, the previous board did not operate like that. So that was different.
And you mentioned that in terms of the recruitment of contractors, it was not something that you dealt with, and you point to your lack of knowledge of the BVI. But there wasn't a sort of advertised process or a tender process in place at all.
Not in that instance. But no, not in that instance.
And is it down to the board to decide who would get the contract to, for example, outfit the building or deal with other matters that were necessary?
Well, ultimately, the board would have the final say in approving any recommendation made. And the final approval rests with the board. You could make a recommendation and the board will either approve or not approve.
If you turn up page 105, please.
Yes.
Tell me you're
Yes,
there.
yes.
We're back to the minute of the 25th of July 2019, and that lists for us members of the board. There are obviously various ex officio members, including yourself and Mr. Sylvester, who I think, from memory, was chairman of the BVI Airports Authority. And there's also a representative, Mrs. Sharon Flaxbridge, who may be there as a BVI tourist board. And there are public officers as well as ex officio members. But in terms of the members of the board themselves, we have Mr. Nathaniel Isaac Sr., Ms. Roxanne Sylvester, who are respectively chairman and deputy chairman, Ms. Patsy Lake, Mr. Vincent Watley, Mr. Keith Flax, Mr. Dabreo-Lettsome, yourself, and Mrs. Tamara Wheatley Hodge. Now, in terms of those appointed members of the board, in relation to this transaction, which is leasing this building from VOP Investments Limited, did any, to your knowledge, did any member of the board declare an interest at any point?
No, I'm not aware of any member declaring an interest, with the exception of Ms. Lake, who I think it may be in the minutes where there was a time I think she left the room when the matters pertaining to that rental was being discussed. So as far as I recall, Ms. Lake would have been the only person who would have declared an interest and excused herself at the appropriate time.
Also listed, and I won't read the names out, but there are various members of staff, and this takes us back to a point that the General Counsel made, which was about someone being an interested party or connected person. Did any member of the senior management team declare an interest at all?
Well, just a perusal of the minutes would indicate that the managers actually were excused from the room. They had already maybe fulfilled their purpose in coming there. And after they left to go back to their posts, to their offices, the rest of the substantive matters and the agenda continued. So at that point in time, they were not there. They were not present.
Thank you. Thank you. If I could just have one moment, please, Commissioner.
Certainly.
Commissioner, I've reached the conclusion of my questions. Can I finish by thanking Mr. Lendor for making himself available this afternoon, and also for the way he has given his evidence. Thank you.
Can I echo that, Mr. Lendor? Thank you very much for your time, and thank you very much for your evidence and the clear way in which you've given it. It's been very helpful. Thank you.
Thank you. I appreciate it. Yes, thanks.
Mr. Wright.
Commissioner, that is the conclusion of the day's proceedings. We start again.
Your microphone, sir.
Yes.
Sorry. Yes, thank you. We've finished for today, and we will start again at 10 o'clock tomorrow with 2 witnesses.
Yes, thank you very much. Thank you, everyone.